Morning.
Morning.
Yeah,
Good morning.
I'm only seeing a few number of students. Mhm. Okay. I think we can start. David. 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 David.
Yes, doctor. Good morning.
Morning. You see, when people hear my voice, they start logging in. Mhm. Now I'm seeing the number is increasing. Okay. Can we have the slides on bottom test? Then I highlight as we prepare for exams. David, you know the group that presented that area of bottom? Yes?
Yeah, it is a group that did the Bolam test. I don't know if someone is online for you to probably share. And unfortunately, I could just try to check here if they gave me and they didn't share their group work. I've been trying to reach out to Peter. He has not been responsive. Uh, And a group member of group three that is available probably to share. I see group three has Munduru, Frida, Sarah, Mugabe Isaac. Or is it the one? Let me see. Let me see. Yeah, Mugabe Isaac, Mundo Dorothy, Margaret, Bwambale, Gorishawa Denise, Anna Mosala. I don't know if they're able to support on that.
Maybe you give us some time. Maybe we sort it out.
I'll also be glad if you sent through the work because those are some of the stumbling blocks I've had to put together to finalize the handbook. And I wrote to your group leader. Unfortunately, he didn't respond. I think 4 years responded for the last 2 weeks. Yes, Ronald, you have something to share?
I was just saying, is it okay to read little about what I have read about the Bolam test?
Okay, you can go ahead and submit.
The Bolam test was the patient was John Hector Bolam, and he had suffered from a severe depression. So the treatment, he underwent electroconvulsive therapy at the Frayne Hospital. So the injuries were that Bolam was not given muscle relaxant drugs or physical restraints. So he underwent severe muscle spasms, causing him to fall off the table and fracture his acetabula, the hip joints. So the claim was Bolam sued the hospital, arguing they were negligent for failing to give relaxants, failing to restrain him, and failing to warn him of the risks. So the ruling, the medical disagreement was doctors at the trial disagreed. One group argued relaxants should always be used. Another group argued relaxants carried a risk of death and that minimal restraint was safer. So the legal standard was Justice McNair ruled that a doctor is not guilty of negligence if they act in accordance with the practice accepted as proper by a responsible body of medical opinion. So the outcome, because a responsible body of doctors supported the hospital's treatment method, the hospital was found not liable for negligence. So in later years, in 1997, there was the Bolito modification. These are the Bolito versus City and Hackney Health Authority case. Changed the Bolam test by giving judges the final say on what counts as a responsible medical opinion. So the facts were a 2-year-old boy suffered respiratory failure and brain damage after a doctor failed to attend to him and intubate him. So the defense, the doctor argued that even if she had attended, she would not have intubated him. A body of medical experts agreed that intubating such a small child carried high risks and that not intubating was an acceptable choice. So what was the modification? The House of Lords ruled that a court does not have to accept an expert medical opinion just because it exists. The new requirement was the medical opinion must also be logical and defensible. If the expert opinion cannot withstand rational clinical scrutiny, a judge can reject it and find the doctor negligent. That was the later modification of the Bolam under the Bolito modification 1997. So in 2015, there was a shift to patient-centered consent. So for decades, the Bolam test dictated what risks a doctor had to disclose to a patient. If other doctors wouldn't disclose a risk, it wasn't negligent to hide it. The landmark UK Supreme Court case, Montgomery versus Lanarkshire Health Board, completely changed this for informed consent. What were the facts? A pregnant woman with diabetes was not told about the 9-10% risk of shoulder dystocia, where the baby's shoulders get stuck during birth. The doctor withheld the risk because she felt it would make the mother choose a cesarean section. The complication occurred and the baby suffered severe brain damage. So the shift was that the Supreme Court rejected the Bolam test for cases involving high-risk disclosure. So the modern standard was the court ruled that the standard for consent is patient-centered. So a doctor must disclose any material risk. So a risk is material if a reasonable person in the patient's position would want to know it, and if the doctor knows that this specific patient would attach significance to it. So that's why nowadays, even when you're going for cesarean, you have to sign a consent form. So the shift has been towards the consent that you get to know the risk associated with the procedure you're going to do. That's what I read about the Bolam and its later modifications, the Bolito modification, and to the consent forms now. Thank you. David, back to you.
Thanks, Ronald. Um, yeah, that was actually very, very clear, and at least you've helped actually summarize the Ulam test. I don't know if there is any other person who would wish to add on to that. Is group 3 ready? Anyone from group 3 that is ready?
Morning, Lakers. Actually, Ronald has mentioned most of the things, but just to add on with a case. Just to confirm if my screen is visible.
It is visible.
Okay, thank you so much. There are many decided cases, international and also in Uganda. But
Yes, proceed.
so there's a case of Irene versus Mario Stops Uganda. This case even went to Daily Monitor, and this lady actually underwent a family planning procedure involving the insertion of IUD. I think it's a birth control method most commonly used by women. So this lady actually suffered pain and complications as a result from the procedures that were used in this insertion of the IUD, and she had actually sued the nurse for medical negligence. And in this case, you're looking at whether this nurse actually exercised a level of skill or that the reasonable competence as a healthcare professional, because when inserting an IUD, then you should be careful, and the procedure should actually be performed very carefully and properly. So,
Wilfred,
yes, hello?
I want to know whether everybody is around. Where is Mugisha? Is Mugisha here?
Yes, Doctor, I'm here. I'm present.
Where is the Wafra? Wafra John? Because my screen is not showing everybody. Wafra John is absent. Where is Rushaba? Rushaba? Doko Isaac? Doko Isaac? Alum Pascal? Alum Pascal. Where is the Ajuro? Ajuro? Because I want to see the number of people here online. Yes, I'm seeing Christian here. By the way, I'll be assessing the last part of your attendance. So inform others, because this is almost my last session. And now most people are not seeing them here. I don't know, they have gone. I delayed because of that. Nishimire Margaret, are you around? Yes?
Yes, Doctor, I'm around.
Munduru Fred? Munduru Fred, you around?
Yes.
Okay. Peter Maria? Peter Maria?
Yes, I'm around, Doctor. I'm around.
Okay. Make sure that you send a message to others, because now we're in a critical examination process. And I don't know that I have seen you. Where is Bambari?
Doctor, I'm here.
Okay. Rachel?
I'm available, Doctor.
Yeah, because the number, when I was looking at your performance, the number was 40 plus. Here, when I look at the people that have attended, you're only 26. You're only 26 here. Okay. Mister, you can proceed.
Okay, thank you so much. Thank you so much, Doctor. I was just with this landmark case of Irene versus Mario Stops. Just a brief background. Irene was actually seeking family planning services from Mario Stops, and a nurse who worked for this company actually made a mistake, because when inserting these devices, someone should not feel pain, but she suffered pain, and therefore sued this company, because she had to even go to outside countries, perform X-rays, and use a lot of money such that she can recover. So it was later found out that this nurse actually did not meet the professional standard of care, and that she was negligent. So Mario Stops was actually held vicariously liable, because the nurse was their employee, and they actually accepted that this nurse was actually working for them, and therefore she was not able to meet the professional standard of care. And later, after Irene showing the proofs of payments and receipts and everything, the court awarded her damages. And when we just take it back to the principles that are laid down in the Bolam versus Friend Hospital Management, you realize that the court held that a medical practitioner is not negligent if they act in accordance with a practice accepted as proper by a responsible body of medical professionals. So you realize that this nurse did not act in a way that is considered to be a standard by the medical professionals. She was just negligent, and therefore that means that she was held liable. And in any case, the Bolam tests or the Bolam versus Friend Hospital Management Hospital would not come to her rescue because she was not actually competent enough to insert the IUD. So that is one of the cases. However, when you go to the Burnett versus Chelsea and Keskin Hospital Management, this case actually involved 3 men who attended the hospital department, and the casualty officer failed to examine them and advised them to return home and consult their own doctors. So one of the men later died from arsenic poison. But although the hospital was actually negligent in failing to examine the patient, the court held that the negligence did not cause the death because treatment would not actually have prevented it, because the officer saw that even if I'm to work on these people, still treatment would work. So in this case, it was Chelsea and Kenskin Hospital which won this case because they could not be held liable in a case that this patient, even if they were given the medication, still it would not help to work for them. There is also this other landmark case which actually concerned a child who suffered severe brain damage following a difficult birth, and the doctors used forceps during delivery in a high-risk pregnancy, and you realize that the House of Lords concluded that the doctor had actually acted in a professional way and a professional standard, and that of a competent practitioner. So even if they went to sue, they went ahead to sue the doctor, he would not be held liable because he did what he was supposed to do, and it was in accordance with the standards required. Still, there is also a case of Cedarway versus Bethlehem Royal Hospital Governors, which involved a patient who developed paralysia following spinal surgery. And actually, the surgeon had not disclosed a very small risk of that complication. And it was actually held that the doctor was not negligent, but this judge argued that the Bolam test cannot govern this informed consent, and doctors should actually disclose these materials to patients. Actually, Ronald has just said some few minutes ago that it is actually key that you let the patient know of the risks involved. Though some doctors realize that they want to first wait for you to ask the risks, then they can tell you. But if you don't ask them, they'll also just keep quiet, which is not actually something good. Then there is also this case of Maynard versus West Midlands Regional Health Authority, where this patient actually came with symptoms of tuberculosis. But both the consultant physician and the consultant surgeon took the view that these other diseases were also possibilities, and the first of which, if present, would actually need steps to be taken at early stages. And instead of waiting for results, they carried out another procedure. And the risk of damage was to another nerve, even if the operation was done. So unfortunately, the risk became reality and the patient suffered paralysis. But then it was said that these experts did something that was professional, that was to the standards, and therefore they would not be held liable because it was actually the right thing to do at that time in order to try to save the parent's life, though the risk that they had anticipated before actually happened. But they were actually trying to help the patient in accordance with the standards. There is also another landmark case of Hodgson versus East Berkshire Area Health Authority, where a 13-year-old boy had hip injuries, but he was not actually diagnosed for about 5 days. And by the age of 20 years, he was actually deformed in the hip joint, and he could not actually move very well because of this. And the judge found that even if the diagnosis had been done correctly, there was still 75% risk of the plaintiff's disability developing. So they were thinking that if this boy had been diagnosed in time, he would not actually have faced the disability. But then you find out that even if they tested him or what, in the professional way, he still would actually be disabled. So those are some of the cases about the Bolam tests. Back to you, David, and back to you.
You have discussed, but how has Uganda courts interpreted that Bolam test? We gave you some cases. I'm not sharing anything there.
So our big convents, I believe we had that.
I remember discussing cases like the Diocese of Yombe, where I showed that they are not provided the apparatus to carry out operation.
I believe how Ugandan courts have also adopted this Bolam test is in a way that even when you go to court claiming that there was negligence of the doctor, still they would follow the guidelines of the Uganda Medical Association to really find out if the doctor performed the procedures in accordance with the required standards.
There was a case, if I can be allowed that one. I think I don't know if they mentioned it last time, of the hepatitis B test outcomes of Namwanje Proscovia versus Geelong Solomon and Kampala Hospital, Civil Suit 289 of 2020, and it was decided this year.
Can you post it to the people? Can you post to other people?
Okay, let me highlight and I share.
And The other group that is presenting, can you copy and have those cases part of your presentation because you never complied with?
Okay, that is the case I think I've shared in the group. So the facts of the case, the plaintiff was an expectant mother, visited Kampala Hospital for routine antenatal care in November 2019. So the hospital's laboratory technician performed a routine blood test using the rapid test kit approved by the NDA. So the screening returned a positive result for hepatitis B. So the conflict was she had already completed her hepatitis B vaccine doses in 2016. So the plaintiff sought an independent secondary testing at AAR Healthcare and Lancet Laboratories, both of which returned negative results. So upon returning to Kampala Hospital, they did 2 tests again, rapid tests, and again they flagged positive. So they advised her to take a PCR viral load test. So the hospital's own confirmatory PCR test came back negative. So the lawsuit was, she claimed the conflicting results and false positives caused intense mental and psychological trauma. So she sued the technician and the hospital, and she sought 200 million in general, special, and exemplary damages. So the court ruled dismissed the claim in its entirety based on key legal determinations. One, it was adherence to professional standards, the Bolam baseline. The court held that the hospital acted with the reasonable care expected of medical professionals. They utilized the NDA-approved rapid screening kits, handled them properly, and did not manufacture the kits themselves. The second one was correct procedure follow-through. Instead of acting recklessly, the hospital followed standard medical protocol by explicitly advising the plaintiff to take a confirmatory PCR test to settle the rapid test discrepancy. Then the third reason was absence of harm or treatment error. The hospital did not prescribe or administer any unnecessary or harmful hepatitis B treatments based purely on the initial screening results. Then the other reason was the discrepancy rule. The judge clarified that under Ugandan law, a conflicting or incorrect initial screening result is not automatically proof of medical negligence if accepted medical procedures and approved equipment were used. That was that case settled in May 26th this year.
Very good. Do you remember the case of Kasaira and the 5 others versus the registered? The registered trustees of Nebi Hospital. We covered that case where he said that the plaintiffs who were children and dependents of a deceased, Mr. Anguyo, Lucy, Madame Anguyo, Angusia Lucy, the deceased. So what happened, I gave highlights that in that case, the lady, the plaintiff were the children and dependents of the deceased, whose name was Angusia Lucy. They jointly and severally sued the defendant. That they sued the defendant in that position were the registered trustee of Nebi Catholic Diocese who owned that hospital. They sued them for recovery of general and special damage for the wrongful death of Lucy, who was their mother, and some were dependents, which occurred on 12th December 2015 at Angala. So the hospital there is called Angala St. Luke Hospital. This hospital is owned by the Catholic Diocese of Nebi. Here, the plaintiffs alleged that the death was caused by the employees of the defendants. Meaning, when I say the employees of the defendants, bracket, I mean the doctors of the hospital, who are acting in the scope of their employment as medical workers of a facility founded and operated by the defendants, bracket, registered trustees of Nebi. So the plaintiff case was that the deceased was on 8th August 2015 admitted at the defendant's hospital, meaning admitted at St. Agnes Luke Hospital, complaining of appendix. The deceased underwent surgery for that condition on 10th September 2015, during which a number of alleged negligent acts occurred, including failure to properly administer anesthetic, failure to ensure an effective and a constant supply of oxygen to the patient during the operation. The other issue was a failure to monitor the vital signs of a patient during the operation. Next, failure to install monitoring equipment to see the lapse. And also the ward staff generally failure to exercise professional care and skill on seeing the lapses of the heart. So, the defendant, bracket the hospital, averred that the death was the inevitable result of a series of medical complications, including difficulty with intubation resulting in cardiac arrest, that the medical team could not reverse despite the exercise of professional skill and care and standard. The defendants, bracket the children dependents, further argued that the deceased was properly advised of the possibility of those complications and that she gave her informed consent to the surgical operation. The counsel for the plaintiff, when I talk with the plaintiff, I mean the children who sued, cited the Bodham case regarding the standard of care, medical practitioners, and concluded that the medical team had failed to meet that standard of care and therefore they were negligent. Are we together? Are we together, members?
Yes, Doctor, we are.
Yes,
Doctor, we
doctor.
are. Yes, doctor, we are. We are together, doctor.
Okay. Also, I discussed also the case of Sarah was same one and another against Attorney General was a case of 2017. Is High Court number 675 of 2006. So what happened in the case of Sarah? Was that not every error of judgment made by a doctor may be classified as negligent. It must be proved that the health worker adopted a practice that no profession or standard would be accepted. So the question there was, in this question of Sarah, was one to be negligent. The court will look at whether all the standard of a reasonable person were carried out. Something that I forgot to teach you is what we call vicarious liability. Do you remember, as everybody understand the issue of vicarious liability? Yeah? Vicarious liability, it means if Biamgisha is working for Mbara Hospital and it is Biamgisha who caused or breached the medical profession, since Biamgisha is an employee of that hospital, the hospital is liable vicariously. As long as, be very cautious here, let me explain. If Biamgisha has got his own hospital, that hospital is in Mbarara, he makes negligence, and that negligence causes a patient to suffer, then he dies. That would have been negligence, duty of care. The duty of care was breached. Because of that breach, somebody suffers and then dies. Now, if Biamgisha had his own clinic, even if he's working at Mulago Hospital, the hospital Mulago will not be vicariously liable because he will not be an employee by then. But if Biamgisha was on duty in Mulago, he commits a felony or commits an error on medical negligence, we shall sue the entire hospital. The reason why you sue the hospital, logically, they know that the hospital has more money than Biamgisha being an individual. So that is what we call vicarious liability in employment law. It is like also if Rachel was beaten up at the university by a fellow student, instead of Rachel is at liberty to sue both. He can sue the student, but also sue Tam, because of some also duty of care to protect and promote health and safety of all other students, free from harassment, sexual, etc. Are we together now?
Yes, doctor.
Yes, doctor.
So that was
It's
discussed.
clear.
That is what was discussed in the case of Muonge against Attorney General. The court had to be satisfied that the defendants vicariously failed to have or exercise knowledge. Because most famous, the question of negligence is whether a professional person has acted professionally. So, what is important there? So, common law imposes a duty on a medical practitioner. When I talk common law, I mean this courts. Case law has been developed by courts. That's what I mean common law. So common law imposes a duty on a medical practitioner to warn a patient of material risks inherent in the proposed procedure. Let me explain better. That when this was discussed by Justice Mbiru of Uganda in Muhoozikainerugaba against Attorney General, that when a medical professional, a doctor, is to do any medical operation, is at liberty, the patient is at liberty to be informed of all the risks that might happen. Failure to do so, the hospital will be liable. A risk material, if in the circumstances of a particular case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach significance to it, or medical practitioner should have written some documentation to that. So, where a doctor says that, where a doctor explains by oral with no evidence, the court will find that doctor liable. Okay? The other point, even if the patient's informed consent dictates that the patient is aware that certain complication can occur, it does not mean that this covers negligence techniques or mistakes that occur during the surgery that are not inherent to the patient procedure. What means that even if you have told a patient of the repercussions that might occur, that doesn't mean that a doctor should just be negligent. The standard, the highest standard of care expected from a doctor should always be observed. So in the other case in Uganda was the case of Kabito against Attorney General, analyzing Boram. The case of Kabito against Attorney General and others. Civil suit number 26 of 2012. So the plaintiff in Kabita against Attorney General, the plaintiffs founded the action in negligence. The alleged lack of proper. Now here what happened? The plaintiffs, those who sued, they alleged that lack of proper medical attention towards the deceased who was in labor. So here the lady was in labor towards giving birth. There was a failure by the defendant, bracketed hospital's workers, to provide life-saving blood, leaving the deceased to bleed, which resulted in her death. The lady went to give birth, but was not supported by blood transfusion, which they could see was very important. And also outright lack of care. The court held that there was negligence on part of the medical practitioner, and Justice Musalu Musena of Uganda, Musalu Musena of Uganda said in that case, the standard of care in medical negligence differs from that of ordinary cases of negligence. If a professional man possesses an art, he must reasonably be skilled in it. He must also be careful. But the standard of care which the law requires is not insurance against accident slips. A charge of professional negligence against a medical practitioner is a grave and a serious matter. It stands on different footing to charge of negligence against a driver of a motor vehicle. The consequences are far more serious. It affects his professional status and reputation. The burden on the plaintiff is to prove that the damage was caused by negligence and was not a question of misadventure, and that burden is to be discharged on respondents of evidence. In other words, the case of Kabito, they found the hospital negligent, and they said, in summary, that when you are considering a profession, this is not a case of driving a patient in a car. It is one of the highest professions that are respected. Any person handling such should have cautious care. Are we together?
Yes, we are, Doctor.
So, in the case of Helen, it was alleged that the first defendant overrided the profession, who is not licensed to practice medicine, dispensed medical advice, and prescribed the metorox drug. This is the drug that was methotrexate. So that's the drug. A person was on a counter, not licensed. Remember, was not licensed to practice medicine, dispensed medical advice, and practiced the methotrexate drug to the plaintiff that subsequently put her life and that her unborn child at risk. The court held that the first defendant acted negligently when he did not allow the Uganda clinic guidelines and when he prescribed that drug without consultation with a specialist that is licensed to practice medicine. On the standard of care, Justice Olaya, retired, applied the Bram test and stated that with respect to medical negligence, the duty to take care is that of the level of following the standard practice and procedure, and what a reasonable ordinary medical profession would have done in failure to do so may impute professional negligence. Let me make this one very simple. That guy was fond of negligence. Well, number one, he was like, most people, we end up going to pharmacies. So whenever a person gives advice, we assume he's qualified. But where he doesn't have the qualification, then would be sued. That would be a medical negligence under Balaam. The case of Bernard Mulenga. I think I'll be almost finishing up this one so that you have more cases. The case of Bernard Mulenga. Mulengani against Attorney General and two others, which is High Court case number 29 of 2011. These are recent cases. So what happened here? One of our justices, Justice Kawito, cited with approval. He tried to use it to refer to an Indian case of Postgraduate Institute of Medical Education and Research, where it held that liability of a health worker, it must be shown that he committed an offense, and such offenses should always be taken seriously and prosecuted. So I've tried to look, because the same, we have covered the Burito, which is very good. You have covered the Mula. This case of Mula is very good against King's College. The case of Mula, the claimant had a wound on the side of his foot. In November 2011, he was examined. Our biopsy was made, and diagnosed non-malignant cancer. The wound failed to heal on July 2012. The claimant underwent surgery in the form of a narrow local extrusion. The biopsy revealed a malignant, which necessitated a second operation to remove the tumor because cancer had spread to the lymph nodes. When November 2011 biopsy was reviewed, signs of malignment were found. The claimant urged that Bolam test was insufficient and urged the court to rely on Penny's case. They found that the hospital were negligent on the advice of the person who had got cancer and was given wrong medication. So I will not go through the doctrine of lepisa liquita. The doctrine of lepisa liquita means that the truth speaks on itself. The doctrine of lepisa liquita. It means that the truth or the facts speak on themselves. That's the issue. So, we have also criminal liability, which we covered in the case of Uganda against Namubiru, Rosemary. Now, This case is a case which is subject to the penal code. A case subject to the penal code. Because the penal code says what happened here, a health practitioner may be criminally liable for her or her actions. So under the penal code of Uganda, any person who unlawful or negligence does any act which is and which or she knows has reason to believe to be likely to spread the infection of any disease dangerous to life, commits an offense, and is liable to imprisonment of 7 years. Should I repeat, members, or you have understood it? Let me repeat. The case of Namaviru. Before I go to Namaviru, a health practitioner may be held criminally liable for his or her action as a medical officer. This criminal action is provided under the Penal Code Act. Section 120 states, any person who unlawfully or negligently does any act which is and which she or she knows or has reasons to believe to be likely to spread the infection of any disease or any disease dangerous to life, commits an offense, and is liable to imprisonment of 7 years. That is the penal code. So what happened in Uganda against Namabiru? The accused was a nurse and was HIV positive. Is alleged to having pricked herself. When I say pricked herself, is where you put a needle into your body. So she pricked herself with a needle, and then the same needle was negligently injected a child with the same needle. Meaning, he has HIV, he is using a needle that he has used on herself, but he is using the same needle to put medication to a younger child who does not have consent. So, the post-exposure PEP was administered on the child, and she tested HIV negative. The accused was charged under Section 171 of the Penal Code in the Chief Magistrate's Court. She was convicted and sentenced to 3 years imprisonment and appealed to High Court. The letter, meaning the High Court, agreed with the magistrate, where the High Court said that the apparent health care worker acted recklessly, that she exposed the baby to the risk of HIV disease, which is dangerous to life. There is a need to protect society from such reckless behavior. This country continues to grapple with various life-threatening diseases. Court cannot shut its eyes from the reality of the situation in which we live. The confidence and trust in the healthcare profession by people should not be abused and misplaced. Are we together?
Yes, doctor, we are together. It is clear.
So that is a lady who used a needle which she had used. The only chance what happened there is that the child did not get HIV. Had he got, that woman would have been charged with murder, sentenced to maybe 30 years. Okay? Another, this is a case to the sisters. R against Batman. That is an old case of 1925. So what happened here? The court considered the question as to what amounts to gross negligence in the eyes of criminal law. A medical practitioner was convicted of gross negligence, manslaughter, arising out of the delivery of a patient in a childbirth. So this is a question regarding childbirth. During the delivery of her child, the doctor eventually resorted to an operation which required considerable force. The delivered child was dead. During the operation, the doctor accidentally removed a portion of the mother's uterus. I said the doctor accidentally removed a portion of the mother's uterus. Full stop. He initially refused to transfer the mother, but eventually transferred her to an infirmary where she was found unfit to undergo an operation and died 2 days later. A postmortem report discovered various internal ruptures and that substantial part of the uterus had been removed. The court held that for a person to be liable for gross negligence, it must be shown that she or she owed the diseased person. He owed the diseased person a duty of care. He was in breach of that duty, and the breach caused the death. It must be shown that the negligence was such that no reasonable person would leave such a person without going to hospital, without going to prison. So now you'll find in that case, the woman was convicted of murder, but then the court put to a less sentence of manslaughter. Now, you people taking people to hospitals, children die, and mothers end up dying. The husbands, be strong. Whenever you go to hospital, get all the medical report. You can sue for damages for hospitals not to kill women in that way. Another case that is very important to prepare for your exam is the case of Adamako. The case of Adamako is a case of 1994, 3 All England at 79. So what happened? This case is very good. Pay attention. Anesthetist, anesthetic is a person who, before you go for operation, will check your blood pressure, whether you have enough blood, etc. Oxygen supply is available. Then you put an injection, which most times makes you half dead. Is that very doctor? Before the operation is done. So anesthetic, in the course of an eye operation, failed to note that the tube used to assist the patient's breathing had become disconnected. We are together?
Yes, we are together.
So, I'm going very slow because I want you now to understand, because this is the last might be the last lecture. So remember, after the patient breathing had become disconnected, after 9 minutes, the patient suffered a cardiac arrest and died. The prosecution alleged that the appellant was guilty of gross negligence in failing to notice or respond appropriately to obvious signs that the disconnection had occurred and that the patient had failed to breathe. That also that he had failed to notice at various stages during the period after disconnection and before the cardiac arrest either occurred or became inevitable, that the patient's chest was not moving up and down. Also not considering the mechanical ventilation machine that was not operating, which could signal that such operation ventilation machine always have signals when they're operating. It was alleged that the appellant had failed to notice the disconnection in the endotrobe and that the alarm on the ventilation was switched off, was not switched on, which is a must that whenever such are going, all these buttons should be on. He also failed to notice that the patient was progressively turning bluish, a color that is known that when you see such a turn is an instance that a person is towards death. It was further alleged that the appellant had noticed patient was progressively blue. He further alleged that the appellant had noticed the patient was that had failed to understand the correct significance of the fact that during this period, the patient pulse and blood pressure had fully dropped, a factor that any reasonable person would see such. Expert evidence supported the prosecution's view that the appellant was negligent. One of the senior doctors by the names of Professor Payne and Professor Adams respectively described the appellant's failure to identify the problem and remedy, which is an abnormal to any medical profession. Another doctor by Dr. Monks, an expert, called the defendant, explained that in his view, there was factors that mitigated the defendant's failure to act as expected. He was of view that another independent problem could have occurred before the cardiac arrest. So the issue at trial was whether his negligent conduct was a criminal. He was convicted of manslaughter. The jury found that the defendant's standard of care is below or fell below a standard of a competent anesthesia. It was held that his conduct went beyond a civil breach of duty of care and amounted to a gross negligence, which should attract a criminal sanction. That was High Court. The same person, the doctor, appealed to the highest court in the land, which should have been like a Supreme Court. In England is the House of Lords. So an appeal to the highest court of the land, or the last court, the House of Lords, he appealed to the highest court of the House of Lords on the ground that the gross negligence test was not the proper test for invoking manslaughter. the case, the judge stated, I quote, "In my opinion, the principle of law of negligence apply to certain whether or not the defendant had the breach, but any reasonable person, the way he had acted, could attract a criminal sanction. And the jury have to consider whether the person went beyond his professional standard. And the circumstances of the case, it was clear that a reasonable doctor would not have committed the errors as in the case." So, after that case of Adamako was applied, so the case of Adamako, for the first time, Minister of Uganda was applied in the case of Uganda against Nachiri Wazam, where the accused was initially indicted with murder and he pleaded not guilty. The indictment was later amended and she was indicted for causing death by a rash and negligence contrary to Section 227 of the Penal Code. So under Section 227 of the Penal Code of Uganda, she pleaded, the prosecution alleged that through her rash and negligence, the accused caused the death of a girl aged 1 year by failing to take her to the hospital for treatment. So I think those cases, with due respect, I've tried to deal with the Yabaram test. I'm not going to go to other countries because time is not our good ally. But I'm sure you have understood. Are we together? And some of those cases pay attention, like Adamako for your issues of examination. Are we together?
Yes, doctor, we're together.
Yes,
Yes,
doctor, we are
doctor.
together.
Okay. Is somebody asking a question? I proceed. Charles, can you proceed, sir?
Yes, doctor. Thank you very much. I'm just comparing some two cases.
Yes.
The case of Rose Namubiru of Victoria Hospital.
In law, we say I'm distinguishing cases as a good law, Charles. Proceed.
Thank you. I'm distinguishing two cases.
Yes.
One of Rose Namubiru at Victoria Hospital in Kampala, who inflicted the kid with blood containing HIV, and another one of Nigeria Hospital, where a young man working in the laboratory administered a drug that causes anesthesia to a lady who had gone for medical support. And then when she went unconscious, the young man did sexual assault on her. After some 2 months, 3 months, the lady was found pregnant when her fiancé came back from abroad and she had not had sex. After long recollection, she remembered that she had gone to the hospital and had some period of unconsciousness. And indeed, it was found out that this young man had done sexual harassment or sexual activity on her that resulted into the pregnancy. In this case, both the proprietor of the hospital and the person who inflicted the and the suspect were both arrested and they arraigned before court through police. But for the case of Rose Nambiru and Victoria Hospital, the proprietor of the hospital, Dr. Kagwa, was never arrested. What could be the reason and the difference in the two cases?
Okay. So, remember the case of Namubiru? Namubiru was a qualified medical doctor who injected herself with HIV and used the same needle to a child. No reasonable employer would expect any medical nurse or doctor to act the way she acted. That's why Namubiru was charged personally and convicted of manslaughter, because we are grappling with a lot of diseases in Uganda. We cannot have people aiding and abetting to kill others in such a manner. If you don't have mercy to younger child, then who else are you going to have child, whatever? In that same manner, though Namubiru was charged alone, the other people were also at liberty to sue the entire hospital for hiring a person who's negligent under vicarious liability. They were at liberty. But remember, the problem in Uganda, lawyers after money. And at times, they don't know that they can have 3 or 4 cases aligned together to get higher damages. And remember, in Uganda, majority of people have not had a chance, most of the lawyers, to study medical law. Remember, medical law is thought to be only for the doctors. And the doctors think are the goddesses of this universe, that they can do whatever they want. Like the death of this younger girl from Karangara. This is a matter that would have been taken for trial to be examined. But the problem in Uganda, unlike where I went to study in UK, whenever there is an issue, Uganda, they make a lot of noise. This noise makes jeopardy of the progress, or impedes the progress. This is a matter that would be taken seriously, slowly, examined, have experts abroad to make their own report, and then aligned before the court, so that no further ladies die. Remember, Mengo Hospital has been found of so many errors. Majority, there is one guy who was operated of the heart, he died. Mengo was found of negligence and compensated it. That was Chikungwe, one of the gentlemen that had contested to be Lord Mayor of Kampala. My case is another factor that when my child got accident, Mengo did like 5 operations, which operations they ended up cutting some of the optic nerves, which they should not. So because of the stupidity of Mengo, I asked them to give me reports on what they diagnosed. They refused. And I was seeing my child was almost going to die. I rushed to IHK hospital. There is a doctor by the name of Dr. Wablindo, the PhD ophthalmologist in Uganda, a senior consultant to Eastern Central and UN. He examined the eye and he found it was in a vegetative state. I tried to fly to Nairobi. Nairobi had a strike. I tried to go to Rwanda. The doctor had gone out of the country. So I was helped by Brigadier Isoke. My son had no passport. My wife had no passport. So Brigadier Isoke, with immigration, they processed the first page of the passport, which I sent to India to get e-visa. As I was getting all that, my passport was being compiled as a book. I never had a full passport. And then the next day, even I got the national ID the same day for the child. And then I rushed to India. Reaching India, I thought we are going to spend like hours, but the doctor only told us 30 minutes. If you delay, the child is going to end up, because the pulse was increasing and was almost going to go to the brain. And I was almost going to get him back dead. So I had to pay for the hospital, consultants, accommodation, and even I think sooner or later, I put a video which is on YouTube, I think, and I think I'll share with you, where I was able, most people fear, to talk about the negligence of people dying, and majority of these were from Mengo, Nakasero Hospital. This is where I found the highest number of patients in India on negligence. Because I had become a victim, I never wanted other people's children to lose their eyes. So I had to put that one up to stop others who might not even have the potential to go abroad. So, when you look at such circumstances, we need to alert you, the non-lawyers, to understand you can take such cases to courts of law. And whenever you go, this system of women sending women to hospital is also wrong, because women become emotional and they don't get even the records from the commencement of the treatment. So where dire situations rise, you don't have the paperwork or the evidence that you can rely on to open up a case against the hospital. Such can be used. Recently, there is a case I was almost going to be killed in Mlago. A boda man, they said the boda man got accident and his leg got broken. When I examined, they said that they took the boda man to hospital and was operated and died. I asked a question which I once asked when my son got an accident, when she was praying and broke her arm. When I went to Nakasero around 2-3 o'clock, the doctor suggested to pay 9 million for the operation of the bone near the neck. I left because I told him that what he was saying, I've never heard about it. With the pain, I got stronger pills for the child to take. I went to Platinum. Platinum did not have the services. I called the doctor at Kampala Hospital by the names of Dr. Mwas, who's a specialist in bones. He looked at the child. She got sort of like a cloth. There is a way he put the arm in a given position and tied him. Then he said he gave us some medication, and I was able to be going there every 2 days. The child healed very well with only, I think, around 800,000 from 9 million operation. And if I had done the operation, the child would have become fully disabled. But I was strong, and I remember getting the doctor into his neck because I was saying this is how they end up their lives. When I was in India, I found so many cases from Nakasa Hospital, especially kidney and others. Recently, I was called by a doctor. I didn't know that they had committed a felony, how to get a visa to Turkey and India, and I was able to connect to those hospitals, and they got all the paperwork. A month later, they called me that, I said, doctor, you know why we called you? Had made an error on a patient, and that family is connected with the government, would have been jailed. So, before you make any decision, it is my kind of appeal. Even if they tell you anything, get like 7 advice from different surgeons. Another man who I went with abroad, he paid the ticket and everything. He had been told that he has got water in the heart, and this needs urgent operation of 40 million. Now, because he sold the land, and he had been told 50 million to do the operation, I asked him to go abroad. When he went abroad, all the machines of experts of the hearts were brought up. The man was in a good state. But because of the fear, I was told after 2 weeks to come back to Uganda. He had to spend a month so that they do another examination. Ever since he came back, he's running and swimming, which had been told by the medical doctor in Uganda he should stop, that his life is in a vegetative state. Now, because of the scam, money making, and those on insurance, doctors have made a guinea pig apparatus test, and Ugandans should stop that. Everything is God. Yes, God is there, but let us be prudent. How our life has become a source of income to those in the medical profession. We have so many others who fail. That doctor who worked on my child was a doctor teaching in Makere Hospital. Noango had ordered him to pass one of the students of a high-profile person in government. I will not mention the name. The doctor said, I'm not going to allow that student to pass. Let him repeat. Because medical profession is a high standard. When he was forced to comply, he resigned and left Makere University for good. The only bad news recently passed on. Since he was a doctor from Russia, he had trained from Russia and Poland. He got a wife from Poland, from Russia, whom he has stayed with her 30 years in Uganda. It was unfortunate that I never had a chance to go for burial. I had gone abroad for medication, and her body was exhumed. When I say exhumed, meaning that it was burnt. That is how the Russians buried. Mr. Mugisha.
Yes, doctor. Thank you so much, too.
Are we together, members? Yes?
Doctor, what I pick from here is the advice you give us of vigilance and taking up these cases. I'm almost in the middle of such. My mother had been hospitalized twice. When I picked her from the hospital, she had been given too many drugs, some of them not necessary, and others treat the same case. So they made her too weak until I sought for a second opinion. They were isolated, left on some, and others removed. Now, because of this weakness, she had gone to take a bath and she fell down. She fell down badly and went unconscious. She was picked and taken to hospital. And on reviewing the medical form, many of these drugs that the first hospital medical facility had given her were not written in hospital unconscious. The recent CT scan show a possibility of a drop of clot on her brain. We are still struggling, but she has gained consciousness, and we are seeing a neurologist on Monday. So you can see there are many things. One, different opinions from different doctors because interest is mainly money. Also, secondly, these negligent actions are not checked and they go scot-free, so they are living in the world of their own. Because of less understanding of this medical law, we are not following up and they are in their comfort zone.
Yeah, that's the truth. And that's why I said, let me sit down, draft a course unit called medical law than what they used to teach, because initially time was just teaching things of contract, what and what. But me, I sat down and I said, how can I transform society? How can I impart knowledge that even on my deathbed, I have cemented a legacy of transformation of the life of the Ugandans and those people abroad from Sudan, South Sudan, Rwanda, etc. So that when I do such things, I have a reason that when God gave me the reason, the medulla oblongata, I can die and I say, yes, by the time God gave me this chance, I have transformed the understanding of those who are non-lawyers, that they don't need to be lawyers to be vigilant, to protect their life that has been taken over by those elites who think they have a right to destroy everybody's lives. So that's why I ended up saying, yes, everybody is a victim of medical, every person is a victim from employment, whether me, whether you, ABCD. Because remember when I told you the episode of my employment, the only thing that I'm patient, I know which buttons to trigger. But imagine another person would be more scared. But some of us, because we have done employment law, a person changes your contract with no consent, then he thinks, oh, this is because I'm powerful. If you don't sign, I'll consider it resignation. Because if it was a prudent resignation, means that two people have agreed and it comes with a financial package. But when people make errors, for some of us, we leave them to make more errors. So that the more they make errors, you are building a better case for litigation. And that is it. So that's why I made sure that you understand the employment perspective. Many of you will find that you have been working, you don't have pension. Or your husband passed on, but you worked for almost 40 years. You were entitled to your pension. Then you should know the procedures of getting your pension. If your employer is not remitting NSSF, what are the remedies? These are the things we are going to go through, because these are daily life. We are all part of them, and we should master them. When you master them, even if you go to a lawyer and the lawyer knows you know what to do, he will charge you less. And even if you go to court, you can also explain on cross-examination. You can explain on oath, and the judge will guide you better in making the ruling. Not everything should be left to the lawyers, because some are just exploiting your ignorance. And I don't want you to be exploited, because at times you don't have enough resources to waste, given the financial predicament and the conundrum surrounding businesses and industries in Uganda. That's why I had to make sure you also learn the structure. What court does what. Clear? Mm-hmm. This is why then, as future leaders, I thought that you should know whether Uganda is fighting with the enigma of corruption, whether indeed it is a myth or not. As part of the entire federation of the East African Treaty, the question of free movement of labor, 770, Article 76, I made sure that you get to know that we are at liberty under the Common Protocol to move freely within the member states. When Rwanda crossed the border, we went to court. Rwanda had to pay money. When Uganda invaded Congo, Uganda was taken to ICC. Up to now, we are still paying that debt. There are so many cases where a Kenyan was sent away from Tanzania. Tanzania had to pay money for breach of the East African Treaty. I thought that one, you know. Uganda having so many refugees from South Sudan, Eritrea, and other countries. We are the leading refugee center in Africa, and in the world, I think we are number 2. With the Bidibidi, Lamon, Nachivare, Chiriangware, and others. So the question of the refugee status to work under the Refugee Act, now they're permitted. Initially they could not work. Now they're allowed to work. It should be, and there is a case in court which has granted them under the court made a ruling and the law was amended that refugees are now allowed to open banks and they can work. So because most Ugandans are elites, they are not educated. When they see refugees working, they make a complaint, but they don't look whether there is a law or there is a virtue and what type of worker is. Refugees are not allowed to buy land of Milo land in nature, leasehold, or bibanja. They can get land for investment under the minister. So if they buy land, they are being hoodwinked. If they go to court, they lose that land because they would have breached the law. We have also managed to look at each country regarding the life health. People from Sudan, I told them to look from the perspective before they separated from Khartoum to consider those developments. I was able to go to Liberia. I was able to go to Botswana, went to Rwanda. That international mechanism is for you to learn how can we learn from one another to make our medical profession better. We looked at the equation, how your contract of employment can be ended. And I had to emphasize on issues of resignation. Where an employee has not agreed upon, then a person pushes him for resignation, that will be unfair dismissal automatically. And then the repercussions of such damage is so huge than wrongful dismissal. I was able to explain what is wrongful dismissal and unfair. Where I said wrongful dismissal is where an employer, you had a notice period, maybe 3-4 months, he dismisses you before you complete the notice period. In the case of Addis against Gramophone, as I stated, that the employer would only pay you the notice period, nothing else, not your challenges, etc. But when it comes to unfair dismissal, any damages can be awarded by the court. That is what I stated. And I gave so many cases on that position. Now, the issue of child, which is an examination area. Let us pay attention. Now I'm on the right of children and medical, which will bring in the scenario on sterilization, the question of circumcision we covered, the question of conjoined twins, and their rights. So I'm starting from Uganda perspective. The Constitution of Uganda, Article 34, subsection 1, defines who is a child, and the child is protected under the Constitution. We also have the Children Amendment Act, which states that the welfare of a child shall be of paramount consideration whenever the state, a court, a tribunal, a local authority, or any person in respect of upbringing of a child, the administration of a child's property, the application of any income arising from administration, a child's position is considered as paramount. So in determining the question of welfare of a child, the court shall have regard to the wishes and feelings of the child. That is a position from Uganda perspective. We all covered the case of Gaelic against West Yorkshire, where the issue was about the consent of the child should be below 16. A child cannot consent to everything. It is all the parents or the guardian. And we discussed the Gaelic test very much regarding the welfare. But let us go straight to the cases that you have read. The case of Risi, which is welfare of a child, immunization. Remember, this is a case where they are fighting between a mother and a father, that when a child gets that injection, her life would be in danger or get pain. So the application concerned 2 children aged 4 and 10, neither of whom had received any form of immunization against the infectious diseases. The father fought to say that the children get such a medication, and the mother was fighting the father because they had been separated. In each case, the child lived alone with the mother, who was opposed to immunization, while the absent father supported immunization. The court held that appropriate immunization was in the best interest of the children. The court said that the benefits of immunization for children outweigh the risk associated with immunization. Are we together, members?
We are together, Doctor.
We are together, Doctor.
Yes, we are together, Doctor.
We are together, Doctor.
We are together, Doctor.
Okay. In another case, because I'm going to be brief, I'm not going to go through too much detail, because some of you, when I go deep, you move off. This was a case of 2013. England and Wales High Court at 2683. In that case, the mother and the father had agreed, following their oldest child, aged 15, having been inoculated. When I say inoculated, is when a person is born younger, before the right age of giving birth. He should not receive a booster, and their second child, age 11. They refused to get that booster, which is so important. So they also said they should not be immunized. The parents subsequently separated in 2011. The children remained with the mother and had contacted the father in 2013. The father sought an agreement from mother that both children be fully immunized, but the mother refused. That one is another case of F and F. The mother questioned the benefits of the vaccine and was concerned about the possible side effects. The father went to court, and the court made a balanced test to the children and made a declaration and a specific order for both his children to receive vaccination. The court held that the children's welfare was paramount, considering the issue, and they said that the vaccination is for the health of the child. The other case is RW, a minor. A minor medical treatment. It is a case of 1992, 3 weekly report at 758. Oh, in that case of RW, an application was made for a declaration allowing a hospital to treat a girl aged 16 suffering from anoxia nervous against her wishes. She had problems with the nervous system, and the parents had refused. So what happened? The hospital went to court because they are minors, in order for the court to grant them consent. In granting the order, the court held that where a competent child refuses to give her consent to the treatment, the court may, in the exercise of its jurisdiction, override the child's wishes in the best interest and give consent for treatment. So, in this case, a child had to be given treatment. Another case, I'm not going to go through too deep today, unless otherwise. A. These cases, even if you go online, you'll get them yourselves, and then you can make your own notes if you want. But I'm giving a summary. Now we have a problem of region called Jehovah's Witness. The Jehovah's Witness do not believe in true blood transfusion. Are together? So, but I assume people are following me.
Yes, doctor, we are following.
Okay.
I don't know. Welcome back. I think that I come here. You're gonna have here. You've been coming here. Yeah, yesterday also I come. And you checked there. Open the door. Okay.
Okay. Remind me, Bwana David and before, when I finish this issue of children, I should be able also to discuss on the adult people, on the issue of consent for treatment. If they refuse, what is next? Can they be forced or not? Because they are not adults, they are not younger children. I should be able to also I should also be able to give some highlights so that everybody understands some of the challenges regarding adults when they refuse to take off, where doctors take action before they accept, and what are the repercussions. Members, did we cast the case of Boritho against Hakini? We discussed it, isn't it?
No. We did not, Doctor.
Okay, let me just give a summary. What happened in the case of Boritho, City, and Hakini Authority? I thought that I had discussed this case because to those cases that one cannot forget. Boritho against City and Hakini Authority. So what happened in this case of Boritho? It is always discussed. It is Boritho, sorry. Boritho against Hakini. What happened here? Let me give the brief facts of the case. Patrick Boritho, aged 2, was admitted to the defendant's hospital, suffering from respiratory difficulties. On the second afternoon of his hospital stay, Patrick was in respiratory distress. A nurse summoned the pediatric registrar. He promised to attend as soon as possible, but did not do so. Patrick appeared to recover at 2 p.m. Patrick was again having breathing problems. The registrar was called a second time, but again failed to attend. At 2:30, the boy collapsed, stopped breathing, suffered cardiac arrest, causing catastrophic brain damage. The hospital admitted negligence on part of the pediatric register. She should have come to examine the child or arrange for a suitable deputy to do so. However, they denied the ability, urging that even if the doctor had attended Patrick at 2:30, she would have got such damage to the brain. The trial judge accepted the doctor's evidence. The question then came whether or not a competent doctor had attended to Patrick, and if he did so, he would have suffered the same damage to the brain. The experts were sharply divided. 5 experts testified that Patrick's history of breathing problems was such that responsible practice required that she would be intubated and would have been given all the reasonable defense. These people applied, made an appeal. After losing the case, they went to Court of Appeal. The Court of Appeal applied the Boram test, and in determining causation, they found the hospital negligence in that manner. Are we together? Yes,
Doctor, we're together.
Yes, doctor, we are following.
The other case is the case of Marriott Hotel, I think, against West Midlands Health Authority. What happened here? The brief facts: the plaintiff had suffered head injuries after fall. He was discharged from hospital, but remained unwell. 8 days after the fall, he was visited by a defendant's doctor. The GP, the general doctor, carried out some basic neurological tests and gave painkillers. 4 days later, the plaintiff collapsed and was readmitted to hospital. He suffered hematoma after the operation, which the doctor never told him. And they applied that the standard of care had been done. The Court of Appeal stated that such would have been avoided. The doctor should have guided. So, why I give such cases is to know that malpractice of doctors globally had become a matter of fact everywhere. Okay? And this is something that was destroying medical profession. They had impunity everywhere because they come up with the rules under the medical council. They have volume test. Nobody challenges them, and so forth. Okay? Which was a dangerous position. So now the laws have tried to help us and to see that that impunity is no longer a factor, that we cannot sue these people, but they can also suffer the consequences. Okay? Let me go back to more issues regarding child and circumcision, ABCD. So now we are finished. Let us go to the case of minor. I think that one I finished. Remind I finished the Glick test. Then the one was on blood transfusion. The one for blood transfusion, which was a case of Riara. I think I gave that case. A 10-month girl was suffering from B-cell B-cell was in the case of Riara, a minor blood transfusion. Blood transfusion. This is a case of 1993. So what happened there? A 10-month girl was suffering from B-cell, B-cell. Everybody knows leukemia. You know leukemia?
Yes.
I don't
Cancer
know.
of the blood.
And needed blood transfusion. The parents.
Peter.
Are we together? Can I proceed?
Yes, doctor, you
can proceed. You proceed, doctor. You proceed.
So he was suffering, and he needed
Peter, are you with me?
A 10-month girl was suffering.
No, your video is on. So we are almost looking at everything.
John, please mute.
Can I proceed?
You can proceed, doctor.
Sorry.
Okay, a 10-month child was suffering from B-cell lymphoblastic leukemia and needed blood transfusion. The parents of the child, who were devoted Jehovah's Witnesses, refused to consent for the treatment because Jehovah's Witnesses, that religion, they don't believe in blood transfusion even if you get an accident. That for them, they assume it is God's plan, let the person die. So they were ready to get their child dead. The parents refused the hospital to provide blood transfusion. The parents who were Jehovah's Witnesses refused to give consent to the child. So what the hospital did, they breached, they never accepted, and they went to court. The court was able to grant the children interest to have the blood, otherwise they would die. And blood transfusion was carried out. That is the case of blood transfusion. The other case looks like to be like a Greek. Re minor wordship treatment. What happened here? A Greek competent 15-year-old boy refused to consent to blood transfusion required to treat his leukemia on account of Jehovah's Witness. This was also another Jehovah's Witness. The parents withheld the consent too. The court also applied. The doctor went to the court and they granted the blood transfusion. Okay. I've covered immunization. We covered the case of congenital twins. Remember, the two twins were born as sisters and brothers. And the hospital found out if they don't carry out the operation, both of them would die. Now, in the operation, one of the twins passed on. The parents took the matter to the court, and the court stated that given these people were two having the same limbs, using the same heart, and one had to die for the other to continue. So the hospital there stated that the doctors were not negligent given the circumstances, how to protect life. One had to die, the other to stay alive. That is the issue of congenital twins. The issue of circumcision, the question was, we went through that case also, where the father and the mother had a child who belonged to the Muslim faith. The mother was not a Muslim. She was of another religion and never believed in God so much. The mother fought never the child to have circumcision. And he said it was the best interest of the child should have aggregate pain. There was no issue so much, they never argued on the issue of medication by then. And the court was in support of the mother. The child was never immunized, was never circumcised. The father argued that all my people laugh at me if my child is not circumcised, and even other children from other wives would seem as unfit to belong to a Muslim family. The court did not consider all of that. They said they just took the position of the mother's position that he would suffer pain. However, if the case was tried today, some circumcision would be defined as medical, and then the court would have considered the matter differently. Are we together? Yeah?
Yes, doctor.
Doctor, we are
So,
together.
cases of R against Adamako, Aborithal, I've discussed them. The case of Namubiru, I've discussed it very well for your examination preparation. The case of congenital twins, you know better. I think the other position that may be R against Adamako, Abakshia, we have discussed. R against Nambiru, we have discussed. Bakshia, yes, we have done. Boram test has been given an upload. Maputo protocol, that one we discussed it very well in class. Everybody, I think, should be well conversant. What else that I need to go through before I go on the medication, consent? The issue of sterilization, we covered the issue of sterilization. We have like 2 or 3 cases you should read and summarize. One of them is where a mother had refused her daughter to get pregnant because she was stubborn. She had got a private doctor so that she can be stopped never to get pregnant. However, the hospital made an application to court and they said they should give a chance to the child to reach 18 to make his own consent regarding sterilization. Then there was another issue where the ventilation was being put off and the parents had wanted the ventilation to continue. When they went to court, the court said the best interest of the child should remain. So those ones, I think I have less problems of people understanding. Let us go to the next position. I think issues of sterilization, transfusion, consent, that one I've covered. Let us go to, can the person who has got to the slide regarding the public doctrine submit so that we can go to the issue of Madden against Madison, the public interest doctrine? Yes?
Doctor,
I'm listening.
I'm requesting for David to help me project. My laptop is running low of power.
No worries.
I am able to discuss that. Probably David can aid me out.
No worries.
Doctor, you had talked about taking us through a scenario where an adult doesn't consent. I don't know if you could also give us as I try to locate that work.
You people, you kill me. You people, you kill me. Okay. In the case of B against NHS Trust, which was ruled by Butler Laws, who was a judge, what happened here? Mrs. B had suffered a hemorrhage in her spinal cord. She had much pain in her spinal cord, which left her paralyzed from the neck down and wholly dependent on the ventilator to breathe. He asked her doctors to switch the ventilator off. She considered that death was preferable to survive in such a state of pain. The doctors disagreed. They thought that she would enjoy reasonable quality of life living in a spinal rehabilitation unit, meaning that he was going to have an operation. They expressed strong conscious objection to killing Miss B. When he first indicated her wish to have the ventilators switched off, psychiatrists questioned Mrs. B's mental capacity. However, she was ultimately adjudged competent to make her own decision. The judge ruled that continuing the ventilation of Mrs. B against her wishes constituted an assault on her and awarded nominal damages of £100. She ordered that arrangements be made to transfer Mr. B to a unit where doctors would be prepared to comply with their request. Justice Battle Rose unequivocally endorsed the value of patients' autonomy. The crucial of the matter always was on the capacity of the individual. Now you could see when an adult makes his own consent, it is different from a younger child. Now this person, you see, he had problems of the neck. She was paralyzed down. She was very sick. The doctor said no. And then the doctor said, since you refused it, and this woman was in pain, the woman went to court. Court gave him £100, so that the doctors can switch off the ventilation. That is the question of age is agreeing for treatment for an adult is different from that of a younger child. We are together? Another case was the case of Smith against Cambridge. A claim was brought by a 28-year-old man who was not warned of the risk of impotence inheritance in his rectal surgery. His claim succeeded despite expert evidence that a body of surgeons did not warn patients at the risk. Now, this is a person who had problems of impotence and had not been told that this is a problem of the family. And when he got the surgery, he was unable to produce. So they had to provide him some damage. Why the hospital had kept such important information. They applied the case of Boritho in determining that question. And others argued that it might have been a problem of the hospital why he suffered impotence. So the question of negligence is wide. I'm only picking few for you to understand. I'm sure you have taken enough knowledge on that part. David, are we together?
Yes, we are, Doctor. Thank you.
Euthanasia, that one you read, there are so many cases in theater. Euthanasia, which I gave you, others defined is called dignified death, where a person goes to a country like Netherlands, Switzerland, a person has cancer, he has got HIV, does not want to live, They can inject him medication to kill him slowly. She can travel from Kampala, from Europe to Uganda. He makes his will, visits all his friends, buys caskets that of her life, prepares for death, because he knows which date he's going to die. Because the medication is set with a given time of death. But I told you, the issue of euthanasia in Uganda is not allowed. It violates the penal code and the constitution, the life to life, and how Uganda has not adapted in other countries, even religious doctrine, cultural norms, etc. Okay. Yes, can you proceed, madam? The public doctrine. Mabra against Madison.
Thank you so much, Doctor. But I'm still sharing the public question doctrine.
As we proceed, before this lady commences, I've given you areas of concentration, topics, what we have done for examination purpose. Remember, I have only given you the Constitution of Uganda, the Pension Act, the NSSF Act, the Employment Act, the East African Treaty, to bring in exams only. So even if you bring them and you have not understood, you have not been listening, you might find challenges. So pay attention to this session kindly. Proceed, madam.
Thank you, Doctor, but it seems David has shared a different one. I'm kindly sharing with him the Maybury case shortly.
We are together?
You can put in presentation mode. You click.
Okay. This is Dominique. Who's this one? Bwana David. David.
Yes, doctor.
Can I confirm that all these presentations have been shared by all my students? They have copies so that they can read and make their own summaries prior to the exam?
Yeah, not all. Unfortunately, the colleagues have not been so cooperative
I don't want that word. I want you to mention me, the people. Because me, where I did my education, being transparent is part of me. That's why I find I get a lot of enemies in Uganda, because the system in Uganda, people are hypocritical. They don't want to say the truth. That's why even at the university, I'm having challenges with the boss. Because I don't like character assassination, backstabbing. I want where I say something in face of a person. And the African people that have had education here, you have so much of lack of openness, which has impeded our economy. So I need to know which people are those, and I can take a decision regarding my coursework assessments. Can I get these people? Because when you say people, even those that have done their work, they become victims. And I need to know who are those people. David,
I don't know if you're getting me. Sorry, I'm in a noisy place. I don't know if you're getting me now.
Yes, I'm getting you very well.
Okay. It's just a few. Okay. Group 3. Group 1 as well. And then so group 5 has sent all, especially the one documents, because it's where I was more interested to be able to consolidate the handbook for this course.
So which topics, David, hold on. Which topics that we are not shared? Tell me which topics.
Yeah, if I go to group 3, assignment 3, which was medical law, I'm still missing the documents from group 2. They haven't yet shared with me. Then when you come to the 4th assignment, I've only received from group 3, group 4, and of course now the last one, which came through from group 5. So I'm missing from group 1 and group 2.
No, David, what I need is the topics of those groups.
Okay, judicial, no. I'm missing one from group 1, group 2, and group 2.
So you're only mixing 2 groups, one on judicial review. What's the other topic?
The other one is on medical law.
What's the medical law?
I'm missing from. Sorry?
What is the topic?
It's only group 2. It's the questions you gave us were all under medical law. All of them. The questions we did were the questions which had. I can just go through them. The Marbury versus Madison.
The one that is being presented.
That is what I have. So for group 2, I'm missing the one that has Susan Akulo, who was a prostitute and a university student, and all those aspects. So it's what I'm missing in that assignment.
I beg your pardon. You are saying a prostitute. I have not got the question very well.
Okay, it was a case. It was a scenario, which was reading from. It was about a student who, a LLB student at Gulu University.
So it is a question on abortion.
Okay. Sorry?
It was a question on abortion.
Yes, abortion.
The international norms is supporting the abortion.
Yeah, domestic laws, international conventions. So I'm missing that one. And then when it comes to the questions around the NSSF, it's actually...
Yeah, that question of NSSF was fully discussed in class. I think by Akuro.
Yeah, there were very many scenarios. Actually, we have the one for group 1 and group 2.
Mary, I'm sure you are the one who presented the issue of NSSF and remedies, because I remember it was very well discussed in class.
Yes, Doctor, and I shared the documents with David. He has them.
Okay. If
yes,
David, that issue is
I have that one, but there are other questions that were there that weren't submitted by the
what was the question? Class. Because I remember he discussed the issue on pension, on SSF, went through pension, where I gave direction that when a person passes on, if a husband passes on and had reached the age of retirement, the first procedure is to go to use Administrator General's Act, because when a person dies, it is the administrator that will declare whether you are a true beneficiary. After getting that certificate of no objection, then you can proceed. And remember, the timeline for getting that pension is 15 years. That was the issue. Then we went to NSSF, where we looked at the exemptions of NSSF, like foreigners, ATC, and also we gave that 10% should be given. And I remember she was able to give very good cases where the NSSF has penalized those who do not pay NSSF. And that is an examination area that all of you should prepare for. NSSF. The other issue is when a person is 45 or 46, as long as that person has been in employment 10 years, he is eligible for retirement under the amendment. Are we together, members? Yes? Okay. Madam, with the, can you continue with your Mabra against Madison so that we proceed? Those people that David has tried to pronounce, kindly share the work by the end of the business today. Are we together?
Yes, Doctor.
Okay.
Thank you so much, Doctor. Our question was relating to Chief Justice Marshall in the Supreme Court case of Mayberry versus Madison 5 U.S. 137 stated that matters of public policy couldn't be reviewed by the court of law. What has been termed as the political doctrine critically examine how courts involving medical law have crystallized and enforced the public doctrine. So we gave a synopsis of what the case was, and this all incepted in the late 1790s and the early 18s, whereby the American political life was dominated by the animosity between the Federalists, led by John Adams, and the Democratic Republicans that were being led by Thomas Jefferson. But during that reign, the Democratic Republicans defeated the incumbent Federalists in the congressional and the presidential elections of November 1800. But the lame duck Federalists retained control, implying that the party that was already exiting its reign retained control by continuously appointing individuals, those who were being called the midnight judges, into offices of power. For example, the Chief Justice position fell vacant, and Adams, the president who was at the tail of his reign, appointed a new person, and that was Marshall, his Secretary of State. And the Senate quickly confirmed Marshall to that position, and Marshall continuously served as the Secretary of State. But during in a twist of fate, William Mayberry also appointed other judges without giving Marshall his commission. And that implied that at the tail of Adams as a president, when the new one resumed the office, he appointed a new Secretary of the State, which really didn't work out for Marshall. So he went into courts, the courts of law, for him to establish why he didn't get his commission. And in the courts of law, at the Jefferson's beast, the incumbent president was called upon, but he didn't present himself. He gave cases that the court didn't have powers to summon him, so they should distinguish between the political question and the public question. So this means they had to really distinguish between the court's jurisprudences and also the executive's jurisprudence. So we came up with some case laws. For example, Sobramane versus the Minister of State in KwaZulu, that is in South Africa. It was a landmark case that was ruled in 1997. And in this case, the facts are Subramani was an unemployed man suffering from diabetes, heart disease, and an irreversible chronic renal failure. For him to survive, he needed continuous kidney dialysis treatment. But the hospital denied him routine access to their machines because they faced severe budget and staff shortages. They implemented strict public guidelines, prioritizing patients with acute, curable, and renal failure for such treatment. So the legal dispute was Subramani argued that the state hospital's refusal violated his constitutional right to life, which is Section 11, and his right not to be refused emergency medical treatment, which lies under Section 27. The judgment, the Constitutional Court dismissed the appeal. It ruled that continuous dialysis for an irreversible chronic illness doesn't constitute a sudden catastrophic emergency under Section 27. Instead, it falls under ordinary health services. So the court held it that the right to health is explicitly limited by the state's available resources and the standard of progressive realization. Hence, if courts forced hospitals to fund indefinite care for one person, it would collapse the health budget and unfairly deprive other public health sectors. We also went ahead and, David, kindly move on, another slide, where the case laws are. So I'm on the slide of the case laws. So we also got another case law from India. That was from Bashim Bagaket Mazodo Summit, passing the state of West Bengal, and it is a landmark judgment of the Supreme Court of India. So under this case, there is emergency medical care as an integral part of the right to life under Article 21 of the Constitution of India. You've moved ahead. So, the facts of this case of Pashim Baga, Pashim Hakim Sheikh, a member of the Pashim Baga family, suffered serious head injuries. Yeah, that's where we have finished discussing the one for Subramani, who needed the dialysis treatment, but he couldn't attain it because the hospital was resource constrained. So we had another case law of Pashim Baga. Move to the next. Yeah, David, the next. It's where I am. I'm yet to move to the Ugandan jurisprudence. Yeah, Pashim Baga, yeah, that is the one I'm speaking about. He suffered serious head injuries after falling from a train. He was taken to several government hospitals that refused to admit him because they lacked the beds, they lacked specialists and medical facilities. So the court wrote a writ of petition under Article 32, which was filed for alleging violating his fundamental right to life. So the issues under this were whether the failure of the government hospitals to provide timely emergency treatment violates Article 21, whether the state is constitutionally obligated to provide adequate emergency medical facilities. So the judgment that was stated, the next is, David, the next slide, please. So the Supreme Court held it that preservation of human life is of paramount importance, and financial administrative constraints cannot justify denial of emergency medical care. So the court also held it that the state has a constitutional duty to establish and maintain adequate medical facilities in government hospitals. And the directions that were issued by the court included: the court directed the state government to increase the availability of emergency treatment facilities and also develop an effective referral and transportation system for the patients. Those are among the amendments that came from the Pashimbaga case of India. So when we moved into the Ugandan jurisprudence, it's where we are having the landmark case. Let me just hold on for David. Yeah, looking at the Ugandan jurisprudence, we are looking at the landmark Ugandan case of Sehad and the others versus Nakaseke District Local Government, civil suit number 1111 of 2012, and the High Court of Uganda ruled that the right of health is justiciable and that the local government can be held legally accountable for maternal mortality caused by medical negligence. So the facts under this case law for the Sehad, the incident is that it happened on May 5th, 2011. An expectant mother named Irene Nanteza was admitted to Nakaseke Hospital, and the negligence is on-duty nurses diagnosed her with obstructed labor, requiring an emergency cesarean section, implying that this mother was having a borderline pelvis, so she couldn't deliver normally. She needed a cesarean section. But the doctor who was meant to write the referral was absent and arrived late, more than 8 hours. And one of the failure is the hospital administration failed to utilize the facility's ambulance to transfer her elsewhere. So the outcome of this is that Nanteza suffered a ruptured uterus and bled to death. The litigations are: the legal advocacy group partnered, that is Sehad, partnered with Nanteza's widow, that is her and her surviving children, to sue the local administration. They began with the Nakaseke local government. They argued that the local government failed in its administrative duty. So on April 30th, 2015, the presiding High Court Judge, Justice Benjamin Kabito, ruled in favor of the plaintiffs. He stated that the court stated that the deliberate delay in treating Nanteza violated her human and maternal rights under Article 33 of Women's Rights of the Constitution and her children's right under Article 34 of the Ugandan Constitution. And then the damages that were awarded, the court ordered Nakaseke District Local Government to pay the family Uganda shillings 30 million in general damages, alongside a 6% annual interest rate until full payment. So this case, the case fought a decade-long battle over the judiciary has the right to dictate health spending to the executive branch. So the political question doctrine is 2012. Initially, the Constitutional Court dismissed Sehad's petition. They ruled that maternal health budget allocations were a political question for the executive. And the legislative branches, meaning the judiciary, lacked the mandate to intervene the way it was during the Mayberry case. So the Supreme Court reversal also transpired in 2015. The Supreme Court struck down the lower court's dismissal. It ruled that the Constitutional Court erred by abdicating its duty and declared that judges can evaluate whether government political choices violate citizens' basic constitutional rights. So upon hearing the merits, the Constitutional Court ruled in favor of Sehad. The court declared that the government's failure to provide basic maternal health commodities and emergency obstetric care directly violates the constitutional right to life, health, and freedom from inhuman treatment. So we let David move on, please. I'm going to the next one. We tabulated it, whereby we distinguished between Sehad versing Nakaseke and Sehad versing Anthony Jenu. So looking into the modern position, in Uganda we have endorsed the balanced doctrine, whereby we are looking at the modern approach that the courts of law are capacitated and they are allowed to look into the government's failure to provide basic facilities in hospitals for people to have access to them. And in the end, in case they don't have this, that means they have denied them to the right to life and the right to health. So courts will, in the modern doctrine, the courts will avoid dictating budgets or policy details, but will intervene where there is violation of right to life. So that means the courts cannot sit, or a high court can detect for Ministry of Health that you're supposed to spend 3 billion in this quarter, but they will only come in to intervene where there is a violation of life, denial of essential health care, and there is a systemic neglect affecting vulnerable groups. We looked into the critical analysis, the strengths of the political question doctrine. It respects separation of power, prevents courts from micromanaging government budgets, and ensures that democratic accountability in policy decisions is made. But the only weakness is that it can be used to avoid responsibility for health failures, and may deny remedies for constitutional rights violation, and also weakens enforcement of socio-economical rights. In conclusion to this, David, please move to the last slide. In conclusion, okay, probably it didn't come there. So in conclusion, in Uganda and similar jurisdictions, the development of medical law in courts has not led to the abolishment of the political question doctrine. They have defined its limits. The doctrine still serves its purposes, appropriate laws, by keeping real policy trade-offs safe from judicial micromanagement. However, it may no longer be used as a general defense to avoid constitutional responsibility for deaths that could have been prevented. So that here, in my conclusion to my own perspective, is that both the judicial statement of recognizing that courts are not to make healthy policy, but are to determine whether the state and all those acting on its behalf have done what the Constitution is required of them, as it was expressed in the Supreme Court ruling with the Sehad case in Nakaseke. Thank you. Back and over to you, class and doctor.
No, what's the name of the student that has just presented?
Chizire Joan Priscilla.
You are? You are Priscilla?
Doctor.
Okay, you have tried to members?
Yes.
That is an examination area with no question. Because I think you have to protect yourselves from such a government. You people who are joining government, you should be well prepared. Okay? You should be well prepared to protect the lives of people as per the Constitution. By the way, in Uganda it's even worse, because now If you bring so much wiseacring to go to court, you might end up going to the basement also. But that does not stop you. I think what is important on our submission, you can look at how Kenya, Tanzania have also done. You get like one case from Tanzania, Kenya, South Africa, and maybe England. Just widen that scope when you are preparing that question of the public interest doctrine and how courts have emphasized that doctrine. Are we together? Yeah? We are together?
Yes, doctor.
Yes, doctor, we're together.
Because that will help you to prepare very well for the exams. Because now you have had a chance of recapping. You see, understanding is like a poverty. We cannot be given the same amount of money. But you would find that if John is using the money to increase on the number of wives,
I knew that was coming.
The other one is using to buy big cars. So when I provide information here, others will be bothered to go and read and prepare. But some will say, I'm not bothered. Then I have no remedy. Then others, it might be an issue of African position of cases. Everything happens is about I've been bewitched. Instead of becoming a solution, everything is about abortion. I mean, everything is about cases. And that one has destroyed African heritage very much, where everything is put to African nonsense, where people don't follow their position. They think everything is about that position, which is very, very dangerous. Whenever a person her life is set on issues of what?
Bunyo. Okuba eri obubi ojja kulaba. Bulabika bubi naye bubadde bulungi.
Lillian, please mute. Your mic is open.
I'm not listening to anybody. Is the class still ongoing?
It is. Concentrate on the text part. Doctor is trying to type there something.
Thank you, Rachel.
Members, are we together?
Yes,
Hello?
doctor, we are there. We are available.
Yes, doctor, we are. Thank you.
On the public doctrine, I don't know whether who was the person presenting on public doctrine.
It's Joan.
It was Joan. I'm here.
Joan, did you cover the case of Kabari?
The case of Kabari. Yeah. We had written it down for our personal revision, but I had it in the presentation.
Why? Okay. That case there, let me first highlight on the public doctrine because I might forget. Are we together now? Yes?
Maybe I request Bambale mute. Bambale should mute his mic. He's interrupting the.
So what happened in public doctrine for Uganda? In Sead against and Kabari, Benon against Attorney General, the plaintiffs or the claimant sought a declaration that lack of toilets and appropriate beddings, the act of undressing patients, detention of patients, and using same rooms was in violation of public doctrine. So, the case highlighted conditions that the government should take. Justice Musota was able to look at what the court can provide in Uganda. So read that case very well. It was a failure to provide toilets and other services to the hospitals around. Okay? Are we together? The other position on public doctrine that should be known, you can look at the special rapture on torture and cruel, which bans a government not to provide services because it will be unconstitutional. So, for examination, it should be able to define what is sterilization, which is defined by use of surgical or non-surgical methods to make a person unable to reproduce. That is the simple definition. Am I understood? I said sterilization is the use of surgical or non-surgical methods to make a person unable to produce. Simple. Okay? And for sterilization, we have other agencies that allow sterilization. First, no woman may be sterilized. The law is very clear. No woman should be sterilized for our own behavior or whatever, unless it's a medical provision. Okay. Any form of sterilization is illegal. And we have gone through cases. Sorry to bring you back. I'll come and clean up. Let me first go with the sterilization because this is an issue of exam. Sterilization. I will define the definition of sterilization, number one. And then, remember, for example, in the case of SC against Hungary, What happened here on sterilization? Upon going to labor, Mr. A, member of the Roman community, needed an emergency cesarean section. A member of the Roman, when I say Roman, that means Black is a Catholic. He needed an emergency cesarean. Immediately before the surgery, a doctor asked Mrs. A to sign a consent form on which the doctor had written a statement that SC consented to sterilization procedure. SC did not understand the statement. She had been sterilized until after the operation took place. For this woman did not know, he never bothered to read. So the sterilization took place. So when it took place, the Commission on the Elimination of All Forms of Discrimination, that case of sterilization is one. And the question that he consented, though he never read, that was enough for her to suffer the consequences. But remember, the Committee on Elimination of All Forms of Discrimination against Women found Hungary to have violated her right to be fully informed consent. There to be fully informed consent, a right of information to prepare him and understand if the questions which were in breach of Article 2 of the Convention of all forms of discrimination against women. Clear? Now, NB, please note, this Committee of Elimination of Forms of Discrimination against Women can also be used against abortion if you're writing on abortion. So, in that position, the committee recommended Hungary compensates this woman for the loss of her life. Altogether, that's sterilization. Another case is the case of VC against Slovakia. Here also, a Roman woman was sterilized in a public hospital during the delivery of her second child baby by cesarean. The sterilization procedure consisted of severing and sealing her fallopian tubes in order to prevent her for fertilization. The applicant's delivery record contained a clear reference to her ethnic origin, together with a request for sterilization along with her signature. Now remember here, this is a woman in Romania who is not like a black person. They don't want them to produce. So when we went to hospital, they gave them cesarean injection birth, which is very, people think it is good, but it has a hidden motive by the white. So he was not, applicant delivery record contained that clear reference. However, the applicant claimed that she had not understood the term sterilization and that she had signed the request while in labor, meaning when you're in labor, you are not concentrated, you are not in the best mood. So her husband divorced her when she heard about that. She had to suffer the circumstances. She took the case to the European Court of Human Rights and found the European Court of Human Rights found a violation of her rights, the freedom from inhuman and degradation under Article 3 of the European Convention, and he had to be compensated. That is the case of Slovakia. In England, we have already covered the case against West Berkshire Health Authority. What happened there? A plaintiff, aged 36, had a hearing difficulty. She could not hear very well. She had been voluntarily inpatient at a mental hospital for over 20 years and had developed sexual relationship with male patient. Both professional and her mother thought that she should not have been pregnant and she should be sterilized. Since she was unable to consent, a declaration. Now the mother got got his own doctor, paid her to sterilize the daughter. Now the hospital refused. The hospital got the information. They went to court. The court said or held that since she was unable to consent, she could not have sterilization. The court held that the patient is competent to consent if she's able to understand the nature and the purpose of the treatment. In this case, this person is she cannot understand. The court held she cannot have the power to consent on the patient's behalf. So the doctors stated that the question was whether she should be lawful to perform sterilization without her consent. The doctor held that a doctor who operates a patient without his consent commits a felony subject to imprisonment. So that is a question on an adult who could not consent and they could not force her. Another good case on consent is the case of government of Republic of Namibia against LM and others. That is a case of 2014. Now what happened here? The Supreme Court of Namibia dealt with the question of informed consent in the context of sterilization. In this case, 3 HIV positive women were sterilized. 3 women who are HIV positive were sterilized. While in labor, the Supreme Court told that the women had been forcefully sterilized without proper consent during emergency cesarean deliveries. The court found that none of the women could have given informed consent as they were in varying degrees of labor. Are we clear? So I go now to Maputo, which you should also know. You should know this issue very much for your exam. Maputo and Maputo Declaration. So the other, I forgot to give damages. Sorry, is how much he was paid. In Uganda currency, if you forcefully sterilize a person, even if you disable it, you should be paid a fine of 400 or go for imprisonment for 1 year. Now, under Maputo Protocol, like it has something with Uganda regarding the question of sterilization. For sterilization of women without their free, voluntary, and informed consent violates all the human rights of a woman. That is the Maputo Protocol. If you're writing anything on Maputo Protocol, that's what you should be able to write on Maputo Protocol. In other countries, parents have brought negligence actions against doctors. For example, in Canadian case of Kelly and others, the parents took the doctor's hospital and sterilized their children without their consent. So I have tried, I think, to say that the question of sterilization of children and the other one, I'm not going so much into issues of infertility because I never had the chance to go through it when we had these issues. But I think now, on sterilization, Maputo, you can write something, and also issue of consent, you know better. Now, thank you, the lady who covered the public doctrine, and I've given you a case of Uganda, the one for Kabali, which you can add on the question public doctrine. Are we together? Who covered that question? Yeah.
I covered it, doctor.
So now you know the case of Kabali. Should be part of your package. Are we together? Whether the government failure to provide toilets and other issues. There is also another one for the one for Yumbe, the one I gave you for Nebi district. There is another case also for Nebi, whatever, where the government had refused to provide services in Uganda. So you have like 3 or 4 public doctrine, which can support you in your examination process. Okay. Now, the person who presented the topic called abortion, can you start? The good thing will go with your penal code exam. Bwana David, who covered that topic?
Doctor, I'm not so sure. However, I'm also saying the time is getting actually too much. I don't know if it's.
I know time, but since it's my summary, I am not going to give you the constitutional right. It will be me overruling your constitutional right. Because I need to make sure that all have been covered. Remember, after this, I'll be fully setting the exam. And you have how many? John Koranga, when are you commencing your exams?
On the 6th.
So meaning you have 1 week from now.
Yes, we have 1 week from now.
Yes. So I think the question of abortion, who covered this topic? Because I want now to be summarized. I have given most of the cases before I go to...
Charles, is your group ready? So that you can present? I said it's group 2.
I'm putting an emphasis because these are areas of examination and I don't want people to complain that paper was complicated. So I'm preparing you early. You fail in your notion. Yes. Kenyera, are you on that group?
I see Lobojo Alfred, I see Charles Mugisha, I see Kwak Peter, Tetri, Alfred, Peter Mariel is the group. I see Wakula Francis, Apai Lilian, Stoko Godfrey, Robert Nderimana. So I don't know if any of you is ready.
David, who's that? Which group is that? Otherwise, I'll skip.
What is group 2?
Now, who are the members of group 2? Are there any members of group 2 here?
Yes. Yes, we are here, doctor.
Apai, can you present so that I can highlight and emphasize? Because we are now in examination procedure. There is no time to waste. That's why I have overruled Bwana David's suggestion, because we need to finish this so that after this lecture, everybody goes and sits down, digests, makes his own summary for the examination. You have only a week to exam. John Adong, what will be the date next week? John.
The next week it will be fast. Saturday will be fast.
Yes,
27th to 2nd.
Yes, that means after this, you'd have reasonable time to read, digest, sit down, make your summaries, and prepare for the paper. That's why I made sure that I have been more involved than when you have been discussing alone. So can I have that presentation so that we highlight areas of concern and then we move on? Lydia and Apai, can you share? Apai.
Yes, doctor, I am here, but I'm not able to share one. It was our class coordinator that compiled the work, and I'm also using the phone at the same time. I'm also on the road, so I can't really.
So who's the other person? And Apai, you are braving in the breach of Uganda's laws. You are supposed to be at home until you clean your homes.
At 10, that one we started from morning and it ended at 10.
Then he said driving what time? From 10.
I left home at 10:40. That's when I left home.
Okay, thank you very much. Who has shared for me? Who's sharing?
Just got it from the group. It is me, Doctor.
Okay.
I got it from the group. I don't know who is ready amongst these the people
Now,
here.
Lillian, can you see or you cannot see our work? Because you are driving, you can't see. Who's the other member of that group? Okay. Go
I'm
down
here,
the
doctor.
slide. Oh, Laboja Fred is around. So, Fred, you proceed. This Laboja Fred will explain on behalf. Proceed.
This one was presented before.
Yes.
I was the one who presented about the Susan Okolu.
Okay.
Yeah.
Yes.
This is the past assignment that was given.
Go down. Now,
Yeah,
this is very good. Now, these sections should be mastered by you, because if you have a constitution and you don't know these provisions, you can't do that work. Okay, go down. That is all. So now, members, what is more important? Oh, you okay? Yes? Whether Susan is liable for abortion. So now, the law is very clear regarding abortion. Those sections of first to go back, I want these people to get these sections in their summary. No, the one for Constitution of Uganda, Article 21, is very important. Then any person. No.
Yeah.
Now go to the next page. Go to SEDA. First go to SEDA where you were. States. Now, these international conventions are so important when you are advising issues regarding abortion. Because now SEDA and others are saying yes. I've also given you the position of South Africa, Kenya, and others regarding the right of abortion. Continue. What you start with the Constitution of Uganda. You go to the Penal Code. Then you go to case law.
Move on.
Then you can consider the international conventions and make your own conclusion regarding when you're advising the other person who has aborted. Am I understood, Charles and David?
Yes, you understood, Doctor.
Yeah. Okay. Go to the next page because this one is simple. We have discussed it so many times. Next. Now, what is important? I've tried to give you Maputo Protocol is important. Those are the international conventions, the Universal Declaration of Human Rights, the African Charter and others, and then other countries which allow abortion. But in Uganda perspective, is a different story. So you look at the scenario. When you look at the scenario regarding advise that person, you should look at it at an informed point of view. Then after you have discussed both international and local, then you can make your own conclusion of that scenario. I think this one is automated. I'm not going to discuss so much. Now, hold on, go back. On this ICC Article 17 is now you have Sedu, you have Maputo, you have ICC, okay? Now, these are the alternatives to Ugandan perspective regarding abortion. But also, when you are also looking at the abortion case, look at the exceptions, the life of the mother, the life of a child. Look at the exceptions when you are advising. When you are reading a scenario, first master the facts of the case, of the scenario, then advise the party as per the scenario. You can say paragraph A is about this, paragraph 2 is this. Then you advise according to the paragraph by paragraph. Then when you finish the advice, you are free to make your own conclusion. Am I understood? It's the same with the case of Marbury. You discuss the public doctrine from America, other countries, you bring it to Uganda. Then you make your conclusion the way the other lady was making the conclusion regarding how the governments are enforcing this. I'm sure they are very understood. Yeah, the same to Bolam test, which you have already discussed. You should know the ingredients of what? Abortion. What about assisting a person to abort? What is the penalties? But if you are assisting as a doctor, is it a question of danger of a life? That should be taken into consideration. Then what about the International Convention regarding abortion? What about the case law and the Constitution? What are the exemptions? Then those are the issues to summarize. Bolam test, the application in Uganda and international, you make your own conclusion. That is covered. Adamako case, Berkshire Health Authority have discussed it regarding mental health and sterilization. Maputo Protocol is about the non-discrimination of women, which we have discussed very well. Now, Madison, public doctrine, very good. We have understood it very well. Okay? I think on medical, congenital twins, you should know the law regarding congenital twins. Regarding taking away the issue of consent of children is very paramount. What about circumcision of a child? What about immunization of a child? All of those cases, we have covered them. If you are advising, you start with the Uganda Constitution, then you can also discuss the right of a child, then you can also discuss the case law which you have gone through regarding immunization, circumcision, the other, then we have also covered the other woman, where that woman was suffering from scoliosis, the one I've discussed about the penal code, the spinal cord, and the question of consent. You should read those issues and understand them very well for examination purpose. Are you together, members? Yeah?
Yes. Yes, Doctor.
Okay.
We are together, Doctor.
The other part that is more needed now is the corruption. Can that person on corruption just show his slide? Then I highlight a few things which everybody, but when you do the corruption, you start with the Constitution of Uganda, you go to the laws passed on corruption, the agencies put, the IGIG, the Anti-Corruption Court, the Financial Intelligence Authority which deals with money laundering. Then you get cases on money laundering. Then you have to do with the issues of what? DPP. Then classical cases like a Kazinda, where the property is being sold. You have the Mabati saga, where MPs ended up stealing and selling Mabati of Karamoja. You have that case. You have cases of General Muhoozikainerugaba, who took money and was taken to Luzira, Michael Mukula, and also Bukenya. These are issues. But also, I remember I sent you my summary of the corruption in the index in Uganda. And I was able to have a clip where I was just talking, being questioned questions on that is 2 years when I was asked about Anita Monga, whatever, 2 years back. So get also that clip. It has more information for you to summarize your work on corruption. However, let me allow the person that present on corruption. If I see something, I can highlight within 5 minutes. Can you present the one on corruption? We are almost finishing. We have like 2 things to go. Yes. Yes. Can you, yes, go to slide number 3. Yes. Now you should know the definition of corruption. Go to the chart, number 4, slide number 4. And this summary is very important for you. Now, these provisions, everybody should know them because this is an examination area. Kindly master this because you have the constitution will be with you, but others you don't have them. Now know what is important under the leadership code. The leadership code tells us every person who works for government, we are bound to declare our income it was every 5 years, now they are making them to 2 years. Now, under the leadership code, Honorable Chams, a member of parliament, who refused to declare, was dismissed from being a member of parliament. Then you can also get other cases regarding leadership. Now, under anti-corruption case, we have cases number 1 Kazinda against Saturday General. We have a case of Nanduto against Saturday General and other cases where when you put in corruption cases in Uganda, even if you're in Sudan, you can get those cases. But if you have also 1 or 2 cases from Sudan where there is anti-corruption, I will allow them. When they talk about PPDA, this is about public procurement, where people have been inflating prices. That is one. The whistleblowing act is people who have got information to go to the IGG and make some position, make some information. And those people those alleged people will be called upon and they will be indicted if it is true. Money laundering, we have cases, so many cases. One of them is the case of MTN and others. Get 1, 2 cases on money laundering, where if they see money on account, where the source of that income cannot be identified, your accounts will be frozen without your consent automatically as a mechanism of fighting corruption in Uganda. Next, now slide number 5. Institution enforcing, we have talked about IGG. IGG is the one that is selling now the product. They have sold off that is my sister. Now they have sold off the property of Kazinda because of the misappropriation of funds in the Prime Minister's office. You can also talk about the case of that man of public service. What's the name? Obo, what's the name? That man of public service. Members, can you remind me?
Obey, Christopher Obey.
That case is very important. Have like 3 cases on those cases that were tried. Then anti-corruption court, there are so many cases you can get 3 or 4. Okay? And how auditors general's report helps on issues of scandals. So these agencies you have put, they are very good, but it would be better also to get Glasgow cases that have gone through those offices. Go to slide number 6. Slide number 6. Is it there?
Yes, it is.
Okay. Now, State House and corruption, recently they got people, museveni even was saying, around 20 people were expelled from State House. They are getting money, lying people that they are going to see the president. So, and also, I know anti-corruption has helped so many is State House number one. The case of Balondem and others who were smuggling gold, and the State House he was able to indict them up to court. So just put in 2 cases regarding State House and corruption, but also make some criticisms, whether these are just political metaphors or their reality. That should be in your conclusion, whether indeed Uganda, given the corruption scandal, whether indeed they are fighting corruption or it is a political goal of misleading. You can also bring in the Baram scandal, whether Baram what is doing is legal or not. Yes, slide number 7. Now, this is a very classic. The cases are there. I'm not going to repeat one by one. The one for Kazinda is the one who took almost 10 billion from the office of the Prime Minister and then was caught and taken to anti-corruption court. He has been in jail for the last 10 years. I mean, he was sentenced 5 years. Now, they have sold up all his property. Next, but you should get other cases like the Mabati saga. I'm not seeing them there.
They are there.
See, that one is very good. You can also discuss now the current government issue where people have been arrested regarding the road scandal. You can also discuss those ones which are current. You can highlight them.
The Mpigi bypass where the engineers have been arrested.
Charles, can you summarize those current issues so that a person like Odongpin can also master that?
I was talking about the Mpigi case,
yes,
where government officials diverted the road direction in 2 places where they had acquired plots, such that they can get a lot of compensation.
Yes.
And the construction of the road has increased more than 10 times, and they have scooped the money through that. They are also getting money from the contractors before they start. The 6% has to be taken off for the big people in government. So far, 6 engineers have been suspended from work and arrested.
Very good.
We have the Baram cases you have been talking about, where it's more vigilantism, and many schools have been found out, including Nabumari, to have a lot of ghost students, and they have been.
And by the way, Chelsea, if the government wants to get corruption clear, it is high in institutions like Guru, institutions like that. Those are the high where they should ask the money for the purpose, whether it was research, whether the research was done, if it was the construction, whether it was done. You'd find these chancellors have scoped a lot of money. And I think when I get to Baram, I'll have to highlight him. Yes, proceed.
Recently, one of these weekends, also, Dr. Rigomunsi went to Mbarara Referral Hospital in the night and found that the medical practitioners were not working, only interns were found on duty.
Now you can see the medical negligence we have been discussing. Such interns end up doing operation when they have no skill, they have not attained enough experience to carry out operation. That is the calling of you people to start igniting prostitution of medical negligence. All of you. Proceed, yes.
And we have the bypass here, where the road bypass, where they have been repairing every other 2-3 months. The minister went there and ordered the barriers to be removed and the road to be opened. And the engineers also who were involved are being investigated. plus the Mtiana-Mbende Road, which has lasted for over 10 years. It's not moving, and the contractor has been directed to complete within the 2 years. If
And
not,
most of the engineers have been arrested of these roads, by the way.
Yeah, all of them.
Fantastic. So, Odongo Pin, you are now getting the question of corruption. Global Fund is a very serious case. That's where ministers Jim Muhoozi was arrested, Michael Mukula was arrested, and others taken to Luzira for taking money. That money was made for what? Mugisha, you know better. One I think was for HIV, the other one was for what?
Tuberculosis and malaria.
Tuberculosis and malaria, which is a public doctrine's position of a state. We go to slide number 10. I think the presentations are very good there. Bwana David, have you shared these slides to everybody, including me?
Yes,
David?
I did, Doctor.
Yeah,
I'm saying David.
Yes. What I'm now going to do, I'm going to share what I have in the group.
Yes.
What I'm going to do after here, I'm going to organize and share all presentations. What I want at least if we could have them together. So if I'm sending the ones of employment law, I can organize them and share them at once. Then maybe follow like that, as opposed to
fantastic. We go to slide number 12. Time is of essence. Yes, 12. These are cases. The one of Lawrence Semakula. And I think that one is self-explanatory. You can read. Next, 13. Uganda against Obora Rico. You have not discussed also, Charles, the issue of Anita Among. You have not discussed the former speaker's issues of corruption scandal and the proceedings. Chris Obori.
This one is for the Chris Obori. Chris Obori one is on this slide.
Okay.
Uganda versus Chris Obori, Ariko, and others.
Fantastic. Make a summary. Can you speak out? Yes. Apai, are you listening as you are driving your small car?
I'm listening, Doctor.
Okay. This system of standing to get chicken and start eating before you listen to me should be aborted. You can ignore your chicken and the plantains. Later on, you'll consume that food. Even it might not be hot. You might get other diseases. So this is a health hazard also. You'll rather listen to me than eating food on the road. Proceed, yes, Charles. Charles? Chris Oboro?
Yes, Doctor.
Hey,
Chris Oboro, Ariko, and others. These are the nature of their corruption case is mismanagement and diversion of more than 27 billion, where senior public officials were accused of corruption-related offenses involving the misuse of public resources and abuse of office authority in execution of their public duties. The legal cases here are whether the accused abused office, caused financial loss, or violated public service and anti-corruption laws. The action taken is that they have been taken to the anti-corruption court for trial under Grade 1 Magistrate Esther Simwe, and they were charged of embezzlement of public funds and money laundering. Anti-corruption court examined the documents and documentary evidence, audit reports, and witness testimony to determine criminal liability under the Anti-Corruption Court Act. The cases are still ongoing. The expected significance is it demonstrates that corruption allegations against senior public officers are subject to independent judicial scrutiny and reinforces accountability in the public administration. Like you mentioned, Doctor, whether this is the case that is supposed to have been started with, or whether it is guided by political interests, that one is still under debate. And it's alleged in public circles that this money was being drawn for the former speaker. And the investigations of the former speaker.
And remember, whatever the speaker was doing it on behalf of the state to get non-NRA members so that these people can become a member of parliament, etc. So now the question, is it political or it is a fight of corruption? Is that now that is the conundrum? We just proceed to 14 and 15.
Actually, Doctor, on that, it's alleged that you remember the president used it to issue out money to the MPs. Now the approach was changed to this one, which was now being managed by the speaker instead of the president giving money directly to the MPs to influence the legislation. So whether it's fighting corruption or it's a political case, the discussion goes on.
But the president also continued giving PDM. PDM money was a lot of money.
So,
and the worst thing, let me highlight, the amount of money recovered is too less than the money corrupted. That should be put in your conclusion. Go to 15.
It's here. That is the recovery drive. And when we go to the next slide, we shall realize that the recovery drive, it's alleged that 20 trillions are lost through corruption every year, but less than 15% is recovered. These are achievements so far in terms of recovery and legislation, which have put in place institutions and growing capacity for fighting corruption over time.
Fantastic.
These are the challenges. Selective reinforcements. That is where I wondered whether starting with the parliamentarians was political or indeed war fighting corruption. I have talked about the raw recovery rate. And you remember one time the IGG proposed the lifestyle audit. It has not been applied, and we see a lot of skyscrapers mushrooming in the town, in the suburbs of town. But how to follow up? The president ignored the lifestyle audit and talked negative about it. The time of trial took 12 years before it was disposed of. Persistently poor corruption perception index. You mentioned about the index. Uganda has 27 out of 100, and it is a very poor rating. Weak whistleblowers protection. People have started hiding. They can't declare information to IGG and other related institutions because the implementation of Whistleblowers Act is weak.
And you know what happened? Whenever you say whistleblower, they use that to make a man against the other person. The so-called office of corruption, they become the state agents of corruption.
Okay. Have some few recommendations there.
Yeah, fantastic. I'm sure a person like Odongping has gained a lot from this, and he cannot fail my paper on claims that I never understood. I'm clear.
Doctor, today you're on my case, seriously.
And They are saying you should buy Lillian a big car, but I don't know whether you have the money, but that will be another issue.
Lillian is not driving, she's just handcuffed somewhere in Kampala.
Okay. Now, Rachel, you are trying to make addendum. You have something to give Lillian, but everybody is now giving Lillian something. Okay, that is very
I
great.
don't have. Those are the reasons some people end up being corrupt.
Mm. So we are fighting corruption together. Okay. Yes, Mugisha, have we finished the slide?
The running conclusion is that Uganda has built a comprehensive legal and institutional act against corruption, and it has produced real results, convictions in OPM, Katosi, Chogam, and growing fund recovery by IGG and the courts. Yet the persistent gap between the scale of 10 trillion lost per year and the amount of recovery, combined with the tendency to prosecute lower level officials, shows the framework that continues to fall short of its transformative potential. Sustained political will, adequate funding, and consistent enforcement against senior officials remain the decisive variables for reducing Uganda's corruption losses. Thank you. Those are the sources.
Everybody now you can see that Charles never left any stone unturned. I'm sure everybody should upload him for the scholarly presentation. Okay. Now, can we put in quickly trade union? I'll just highlight a few things and then I go termination, then we end the entire syllabus. Members, I am sorry, but for preparation of the exam, when a student fails, I have also failed. I prepare so much my students that I don't leave any gap of any student to fail, unless it is his own choice. And in some cases, from African perspective. Okay? Yes. Make sure, rafiki yangu Bwana David, make sure that you send me, I don't stop zipping these things. Even when you are sending me, I was suffering with the zipping of getting the codes out. Make sure you don't zip these things, even to other students. Bwana David, am I understood?
Doctor, I stopped doing that.
You don't zip.
I'll send you.
Even all of these try to send me this work with no zipping, because I cannot open it unless I've downloaded it. Then what and what? No, make life easier for me. Or you send all of them with no zipping. Okay, can I, Rachel? Who presents something on trade union? We need to do this one very quick. What is more important on trade union is the mechanism of solving disputes, number one. Number two, issues of inducement of a breach of a contract. You should get a case law and understand. What about issues of intimidation, conspiracy? Then last, interfere with the contract of trade. Make some summary on such issues. Then the rights of refugees we covered. Because refugees in Uganda, I need you are giving me the law, the case law regarding the allowing two cases that you need on issues of refugee. Okay? Then I think last but not least, let us go to who did that question of trade union? I've highlighted the few. Who did that one? Odongping.
It's group 2, I think, also.
Okay, let them just do 5 minutes summary. Then we go to termination, and then I know everybody has now the capability to sit down, digest, and understand. By the way, we attended the meeting of the standing gauge railway. They want people to buy shares of 1 million. That could be under takafur. Takafur is an Islamic perspective where it is like a form of a bond. So follow up the direction to those of you who want to make investment for your children in 10 years. Try to buy these bonds. The advantage when you get a certificate, you can even sell that certificate to any bank. Bank will give you money. And then for them, they remain with the certificate, whereby if it grows, they can make more money than you who wants to get your money quick. So those are highlights I thought I should also alert you to know. Yes.
Maybe, Doctor, in regards to trade union, there were 3 questions. One of which is what Charles is going to present on historical development of trade union. And then also there was another one from Professor Noah in his book, Employment Law and Personal Policy Promotion of Legal Jurisprudence have curtailed the expulsion of the trade union's members' rights under common law doctrines and statutory. Examine the above statement. And lastly, the various modes through which trade union disputes are resolved, and then theories of trade union.
Can you go to the mechanism of? Can you go? Yes, Charles. I want you to highlight number 1, the dispute resolution mechanism, and the question of intimidation and others. I think those should be the first highlighted areas. I want to see if people understood them.
Dr. Ours was about how the trade unions developed, the historical perspective.
You don't have time for that. You
Yeah.
don't have time for that. To go to the next one, because now I don't want people to be here too long.
That's why I have removed it from the screen.
So John,
But
John,
David, make sure
Yes.
you send me those slides, Bwana David. You send them to me, okay? Yes. Let us go to the
All the slides are with you. All the slides are with you, Doctor.
Okay. Now let us go to dispute mechanism of settling disputes.
Thank you,
Yes.
Doctor. Our
Yes,
question looked at. Thank you. Our question looked at how to examine the various modes through which trade unions dissolve their disputes, and it had a part B of the section which looked at the theories of trade union. But I'm going to really emphasize on the modes of resolving the trade union disputes. We began with the definition of what a trade dispute is, and we said it is a dispute between a group of workers and their employer, or between workers and workers, which relates wholly or mainly due to a number of issues.
Priscilla, just a second.
Yes.
Please, those who belong to Orishaba, Dennis has not been able to attend. He's telling me he has been busy mobilizing people to clean cities. So make sure you support him, because he invested more in cleaning than his course unit and exam. Okay, proceed, Priscilla.
Thank you, Doctor. So we looked at a dispute is mainly a disagreement between a group of workers and their employer, or workers and workers. And we got this definition from the Trade Disputes Act of 1985. And we mainly looked into the conditions that aggravate into these disputes relating to pay, terms and conditions of the payment, and the trade union recognition. So in Uganda, trade unions and labor disputes are strictly governed by a robust statutory framework designed to maintain industrial peace and economic stability. And this is mainly reflected in the Ugandan Constitution of the 1995 and the Labor Disputes, in brackets, the Arbitration and Settlement Act of 2006. So when I moved to slide 3, I gave one of the first mechanisms, which is direct discussion and collective bargaining. So under this, we looked at it as being the fundamental or the first stage of resolving industrial disputes. and its main relies on a signed collective bargaining agreement, implying that a specific internal dispute resolution procedure is outlined within an active industry, and people agree on this. We went beyond Uganda and we gave an example of South Africa, where we looked at ESCOM wage negotiations in 2026 this very year. In South Africa, trade unions representing ESCOM employees engaged in a collective bargaining with ESCOM management over salary increment and working conditions. So several unions negotiated for the increased wages due to the rising living costs in South Africa. So when I moved to slide 4, so this so we also
Priscilla, you are on and
so
off.
have one here where in Uganda we had the Uganda National regarding overtime allowance case of Uganda Civil Service Union. So we moved into another by a labor officer. So with conciliation, it's where an impartial third party attempts to reconcile the differences between the two sides without imposing a solution. And here, we looked at how it assisted in the max industrial relations services, whereby bilateral internal discussions broke down DASA that mandates that handed labor dispute must be reported in writing to a localized labor officer, and under section 4, the labor officer has 2 weeks to intervene by appointing a neutral third party or personally guiding the two conflicting parties towards a voluntary settlement. It looks similar. It is more of synonymous to the conciliation process. However, most times it is interchangeably used. Here, the mediator facilitates communication to help the parties reach a mutual accepted settlement. So here we give an example of Tanzania, where the health workers have engaged with government authorities through negotiations over delayed salary allowances and working conditions. So they negotiated between union representatives and the Ministry of Health were used to avoid strikes in the public hospital. And even another example is, for example, in Nigeria, the Dangote refinery labor dispute. The Nigerian government mediated between Dangote refinery management and the oil workers' unions after allegations of unfair dismissal of unionized employees. We also gave another example of Uganda Citibank Uganda versus Samson Ayebare, labor dispute appeal number 018 of 2021. The industrial court regularly reviewed cases coming out of this process, pointing out that a labor officer cannot legally mix mediation and arbitration processes. So to us, the last stage was arbitration and adjudication. So this is mainly utilized where a neutral third party hears the evidence and renders a decision that is often binding and final. So here with that, we gave an example of where a labor officer refers the matter after failing to resolve or conciliate the dispute between 8 weeks. The minister refers the dispute following a formal notice of unintended strike or withdrawal of labor. Then an appeal is logged against the final determination and an order made by a local labor officer. So here we also give another example of South Africa, medical workers in Uganda, Uganda BV, that is labor dispute reference number 156 of 2015. So with that, only that we didn't quote for you we also had another case of where teachers in Nakaseke were forced to sit exams after students failing. So the local government wanted to really get to know whether these teachers were competent enough to answer the exams. And here, the last case of adjudication was undertaken. Thank you. Back and over to you. I think the theories, we can omit them for now. Thank you, class and doctor.
Okay, but yes, that is very great. But I need you to also to highlight the issues of trade union, like issues of intimidation. Who covered that?
We covered it, sir.
Okay, can you go there, Alfred? Issues of intention to break a contract, inducement. Can you go there, please, so that we conclude very well? Like inducing a breach of a contract. I need like one case or two. Intention to break a contract. Interference with the contract of business. Intimidation and conspiracy. Are you together? Fred. Fred.
Yeah, we are together. I'm looking for it.
Okay. Great. No time. Yes.
I hope you're able to see the slides.
Yeah.
Yeah. This is the introductions about the trade union. Doctor, you're asking on the area of
Yes, proceed.
I can proceed. Trade
Yes.
union. Yeah, that's all. I hope the slide is visible to everyone.
Yeah. Okay.
Is it my internet that has gone off?
I'm there. You're on.
Thank you, sir.
Because he has finished issues of collective bargaining, recognition. Is that all, Mr. You had to submit?
Yeah.
Okay. The case I've given there, the case of Makuru Island shipping, 1983. It was said that now this is where I call interference with the trade. When does trade union interfere with the trade? Now, this may be viewed as either a further extension of the torts of inducement. When I talk about a tort is a wrong to breach of a contract. Now, this may be viewed as either a further extension of the torts of inducement. Now, in the case, the case of Makuru, the case of House of Lords, where it was said that there was no need to prove interference with any particular issue. So now, what is important to these cases? Number one, in the case of Makuru, the simple facts were as follows. The International Transport Workers Federation, in their campaign against low wages, organized the boycotting of a Liberian registered ship in the River Mersey. This resulted in the disruption of a contract of hire between the owners and the hirers of the ship. The contract included a clause which provides that Cancellation of the contract was permitted, and the payment of hire would cease if the ship was boycotted due to industrial dispute. Those were the simple summaries of the facts. So now, the owners of the ship, seeing these people are having a strike, they took the matter to the High Court, the last court, the Supreme Court. The judge in the case was called Lord Diplock, said, number one, that exclusion clause did not affect the liability of the defendants for indirectly inducing breach of a contract. Number two, they should pay damages for breach if caused. So now, when they talk about interference with the contract of trade, at times you find that these trading people have the motive of money and they want to frustrate the business. How can business people do or protect themselves? In the case of Taro Hotel, the plaintiff hotel owner criticized the defendant's action, who are telephoning other people not to provide services of any hotel around. So they have to take them to court. So now, I want you to understand, because this, whatever I'm discussing, is an extension of trade unions, which you have covered, and which will be examinable. Are we together? Now, if you don't master this, you might have a problem in handling issues of trade union. So I thought I should highlight those terminologies for preparation of exam, because if you don't understand them, you might not get it very well. For example, if you are the word called restraint of trade, it means no employee should compete with his own employee to compete with the employer. For example, if Charles leaves my shop, she cannot put up a shop next to me. Those are times that will be restraint trade, should be in violation of restraint trade. If also child has got some trade secrets he stole from my company and is using them, I can have a position before court. Okay? So trade union can be defined by a Trade Unions Act of Uganda. Number one. Trade unions, yes, they are allowed to do whatever they want, but they are not supposed to cause total frustration of business. For example, in Tarok Hotel, this is the summary of Tarok Hotel, which I've given you. Headline: interference with the contract of trade. Tarok Hotel Limited against Cousins. ESO had a contract for the supply of heating oil to the hotel. When I talk about oil, that we know when it is winter, there is oil that is provided to these machines in the rooms to provide heat. Are we together? A clause in the contract stated that ESO would not be liable if they were prevented from fulfilling the contract due to labor disputes. It meant that if the rooms are very cold, ESO cannot provide the oil to be used in the hotels, they will not be liable. So ESO were advised that Imperial Hotel was blacked following a labor dispute involving the transport and general workers and various hotels in the area. As a result, ESO did not supply oil to these hotels. An argument that the actions of the trade union had led in the active form of tort inducement that caused these hotels to make a lot of losses. So they had to go to court. Going to the court appealed They went to High Court, up to the Court of Appeal, where the trade union was found to be liable. The commentary I made from this case, I said, this decision amounts to considerable extension of the tort of inducement to breach of a contract laid down in Thomas against Lady. So the issue here, the trade union, by calling other people, so that it was one hotel, but even other hotels suffered, they are to pay cost as a trade union. Another case of Makuru Island Shipping. Here, the plaintiffs owners of Liberian registered ship crew. Mainly, this was more of people from were Philippines, who were apparently paid less money. When the ship was ready from Liverpool, the union persuaded them not to remove off the goods. So the ship owners sought an injunction to stop the interference of the union, which they said was a total of inducement to their contract. The House of Lords approved the reasoning of the Rodeni interlocal case and confirmed that the interference with the contract of trade was an extension of indirect interference of business. That was Makuru. Okay? Now, the other one, which I never gave you, is the leading case of conspiracy. Conspiracy means you conspire with others to cause commotion. This was discussed in the case of Queen against Leather, where Queen threatened the employer of the union that all people selling beef around would not give meat if that one employer of that company was not given the new amount of money needed. So members, those highlights are for you to go and make a summary of different cases on intimidation, breach of contract, conspiracy, and intimidation. Now, last but not least, is what we are going to, this is my last topic, is the termination. Termination of employment is one of those questions that everybody can pick, and then you pick other three from other areas. The question will be made of eight or nine questions. You are picking only 4 of what we have discussed. Now, let me be the person presenting for you the termination element so that you don't get so bored. First and foremost, a contract of employment can be terminated by resignation. Resignation means where 2 parties, the employer and employee, have agreed to terminate their contract with the financial support. This was applied in different cases on termination. But the best case for you on termination would be the case of London Transport Executive against Clark, which is a case of 1981 Court of Appeal. What happened here, the applicant was employed as a bus mechanic, requested unpaid leave to visit his family in Jamaica, full stop. His application was refused, full stop. The applicant was told that should he go without permission, his name would be removed from the registry, full stop. When the applicant went on holiday, the employees wrote to his home address requesting for an expression of his absence, full stop. Later, they wrote to say that if no expression was forthcoming, she would have terminated his contract under resignation. When the person came back, he sued the company. Now, the Court of Appeal said this was not termination by resignation because people, where there is resignation, 2 parties agree, but here it was 1 person. That is one of the cases on resignation. The other case you can get is called Quick Fit. Is a company in England which is like is a form of a garage. Now what happened there? Linham was the manager of one of the company's depots branches. After a security officer reported an incident, Linham was disciplined by the divisional manager. During a 2-day interview between Linham and the crew, the other one was told to go and write a letter of resignation. If you don't, she's going to be dismissed. The court said you cannot force people to resign. So that is, those two cases can guide you on what we call resignation. Now, the next is subsequent agreement as a form of termination. This was discussed in the case of Igbo against Johnson Matthew. Johnson Matthew. It was a case of 1986 Court of Appeal. What happened here? Mrs. Igbo had requested and had been given unpaid leave. So go and visit his relatives in Nigeria. She was a Igbo from that place of Biafra, Delta State. Before she left, he signed a holiday agreement that she will be back on 28th September 1981. And also they said that if he does not come back, she would have terminated her contract. Now, Mrs. Igbo was able to come back to UK before that date. However, she became sick. When she became sick, she was unable to report on duty. The employer terminated her on the grounds that that was a subsequent agreement. The court said no. Since she was sick, her not coming to work was not because she failed to come back to UK. And the termination was unfair. And the court went on to say, if you allow people to dictate that life, they would make life of employers to be like slaves. Another case that is very good for you is the case of Humber and Beach against University of Liverpool. What happened here? The two cases can be distinguished, as Charles was saying. Here, in Humber against Liverpool, a circular was sent around the university requesting for premature retirement among the staff of the university. Humber and Beach volunteered and received enhanced retirement packages. On their termination of employment, they went and said they had been dismissed and went to court. When they went to the court said no. This case is distinguished from Igbo. Here you agreed, you volunteered, and you also got a financial benefit. That is subsequent agreement. The other one is called termination by frustration. Frustration, one is going to be frustration by illness. This one was discussed in the case of Pusad against Spears. Now, that is one of the oldest cases of 1876. Here, a plaintiff was opera singer who agreed to sing at a defendant's theater for a period of 3 months, full stop. Just before the opening of the night, she became very ill and became sick, taken to hospital. She was unable to perform. Later on, he recovered and he came back to perform. Pusad said, since frustration is an event where both the contractor and performer come as an instant from God. Since you became sick, we hired another person to perform. Now Spears went to court, and their court said, given the circumstances of the illness which occurred that prevented the other person to perform was enough to frustrate the contract, and that was it. The other good modern way of frustration is seen in the case of Egg Stores against Libovich. Egg Stores against Libovich, which is a 1976 case. What happened here? Libovich was working for the company almost 27 years. As he was driving, he got an accident and was away from work for only 4 months. When the employer got about that, she employed another person to replace him. Then when Libovich went to the court had to make 3 issues. That before you terminate such a person who has worked for 27 years, consider the length of employment, how long he had been expected for the employer to replace him, the effect of that illness, if that person has got like a cancer, ABCD, and also whether the wages were being paid when they were sick. And the court said, given the nature and the longevity of that person, the termination was wrong under illness. Now, the last one on illness is the case of Notcat against Universal Equipment. (1986). What happened here in Notcat? Notcat had worked for Universal Equipment Company for the last 20 years. Full stop. In 1983, he suffered heart attack. Full stop. After several months of absence, the employer requested a medical report from his doctor. Full stop. The prognosis was that he was unlikely to return to work. Some 8 months after his heart attack, he was given a notice period to prepare and go. Now, due to a dispute over sick pay, the employer urged his contract to be terminated by frustration. Now, this person said, no, I had some notice and I should be paid. When he went to court, up to Court of Appeal, the Court of Appeal said that the principle laid down on illness was sufficient for this person, for his contract to have been terminated. That is frustration by illness. Another mode of termination is called frustration by imprisonment. This happened in the case of Hell against Murphy Brothers. So what happened here in Murphy Brothers is a case of 1974. What happened here? The applicant had worked for the company for 25 years, but was sentenced to 12 months in prison for unlawful wounding a person outside work. On release, he went straight to his job to start working, and he was told the vacancy was filled by another employee. He went to court. The court said, Lord Denning said, that upon a committal for 12 months, an employee has terminated his contract. Are we together? The other form of termination would be expiration of contract of employment. Now, you can use the case of Byarugaba against NSSF. When Byarugaba's fixed term of a contract ended, she could not be renewed. The same with the Kadunabi against URA. Okay? Another case is the case of Dixon against BBC 1979 Court of Appeal. That when your contract is fixed and the contract ends, it is not automatic.
Example of Byarugaba, we didn't hear it. You were on and off.
Byarugaba was a former director of NSSF, and his boss was the Minister of Gender. That's the wife of the wife of Akena. What's the name? Amongi. So when the contract ended, Byarugaba applied for renewal. They refused to renew it. He went to the court. Justice Sekana had that judgment when he was at High Court. And the issue was whether it is automatic for a person's contract which is fixed to be renewed. The court declined and stated it is not automatic. So that's how Byarugaba lost the job. The same with the Kabushenga. Together?
Yes, we are together, Doctor.
Now, the other form is constructive dismissal. Constructive dismissal, I said, is where you want to work, but the employer is making your life so hard. For example, you were dean, but then you are getting orders from a subordinate. Like me being a dean, then it is Abe giving me the order. Number two, you find concoctions where a lecturer like Abe, a coordinator of LLB, was using students against the dean and the lecturer. Number three, where you have changed now my contract without my consent. I can leave Utam sue constructive dismissal that the employer has made my life unbearable, that no reasonable person, you want me to work, but you want me to work on the same terms, but the money from 4 million is reached to 2 million. That is not reasonable. That is what we call constructive dismissal. Okay? This was discussed in the case of Western excavating by Danny.
Doctor, I'd like to make an inquiry on that. When we had an organization parliamentary act changed.
Let me first finish. You ask me.
Okay,
Keep that question. So, what happened in Sharp against excavating? The applicant had been suspended without pay by the employer as a disciplinary measure. Are you clear? For taking 1 day off without permission. This put the applicant in a severe financial difficulty. In order to obtain accrued holiday pay, also, in order to obtain accrued holiday pay and pursue unfair dismissal claim, he resigned, arguing he had been constructively dismissed on the ground that the employer had acted unreasonably by refusing him a loan in advance and when the family was in a financial need. So Denning said, where if an employer is guilty of a conduct which brings the breach of a contract due to constructive dismissal, where the behavior of the employer makes a person or no reasonable person to work in such a position, that person is dismissed by a constructive dismissal. The other issue is the case of Lewis against motor garages limited 1985. What happened here? Lewis had been demoted from a position of sales manager. As a consequence, he lost his office. He was given a small company car and his salary was reduced. After numerous incidences of reconciliation, the manager refused him chances. He left and he said that implied term of mutual contrast and confidence was breached, and the judge agreed with him. That is dismissal. The other one is called summary dismissal. This was discussed in the case of laws against London Chronicle. London Chronicle. It is a case of 1959. So what happened here? Let me give a very good example. I'm going to use Charles, Priscilla, and Mbabazi. Now Mbabazi is the CEO of the company. Rachel is a station manager of Shell, maybe Shell or Kabalagala or anywhere. Now, Priscilla is a staff. Now, what happens? Mbabazi calls Kabule in a meeting. As Kabule is coming, Rachel, she's escorted by Priscilla's staff. When there was a heated meeting in the staff between Mbabazi and Kabule, Kabule left. Then Priscilla, seeing his immediate supervisor moving, he also moved out. The CEO told him, if you move out, you'd have dismissed your contract. And later on, he dismissed him or summarized. When they went to court, the court said no. There was no any harm the other person has done. Because for there to be a summary dismissal, an important term of a contract should have been breached. For example, being a lecturer, you are setting exams for sex, you are setting exams for money, or you are working in a company and you are taking money for the company for your own benefit. If you're a soldier, you are sending out important information of the state, they can dismiss you summarily. So I was giving that example. So now, let me go back to laws against Land Chronicle. Some weeks after joining the company, the plaintiff here, Laws, was dismissed on spot for refusing to obey a lawful order by managing director to remain at a meeting. The plaintiff argued that her manager had moved out with him and had not done anything wrong. So when he was dismissed, he went to court, and the court ordered his immediate action to return to the job because there was no evidence of any wrong he had committed. Are we together? Members, are we together? Yes?
We are together, Doctor. Yes.
The other is termination by lack of adaptability. So now, when a person does not adapt, this was discussed in the case of North Riding against Butterwick. What happened here? Let me give a live example in Uganda, then I'll go back to the case. You'll find Charles is a man working in Katwe or Sudan, and is a mechanic. He's only used, Kenyana will come to you, he's used to day-to-day mechanics. Now, a new company came and bought that company. When he bought that company, straight away, the new company said, when you are a mechanic, you also become, you are going to be doing some paperwork. That's what happened. So North Riding, because he could not do paperwork, he's only a mechanic. She said, I've been dismissed because of the job is not there. She sued the company. The court said, no, there was no termination. It was your lack of adaptability. Okay? that is something that I thought the other issue, like the last case I forgot on constructive dismissal, is the case of Akata against United Bank. So what happened here? Akata was told from a distance from Kabale to Arua. She was given 2 days to leave the company and go to another place, a branch of the company, with no any financial support, with no any car. So Akata refused to go and said the employer had breached a doctrine of mutual trust and confidence. She had made her life so hard, and then Akata was compensated for unfair dismissal, that the action of the employer to give him a short notice with the family to search a longer distance from Leeds to Birmingham was so unreasonable that no employer, even if she had a mobility clause, should move that way. Members, I think we have fully concluded the issue of termination of employment. There are some cases in Uganda you can get, like the case of Geraldine and others, on issues of wrongful termination, which you have now in place, constructive dismissal and others. So, today, I have fully made sure I recap the entire syllabus so that I give you room to go, digest, read. If there are any issues of lack of understanding, you can use the platform where I can be involved to answer any question pertaining to where there are some challenges or legal gymnastic pertaining to medical, employment, and others. A point should be noted. You will not have a question on judicial review, but it is an area that you can use when you are highlighting your knowledge. Are clear? You are not going to have a question on evolution of trade union, but you can have another question mixed with the other things to advise a person for question purposes. Are we together, members?
We are.
We are together, sir.
We are together, Doctor.
I'll try to simplify your areas of concentration, and where you have seen putting emphasis is you should also put emphasis when you are reading. Please come to exam with only what I've asked you to come with: the Constitution of Uganda, the East African Treaty, the Refugee Act, the Pension Act, the NSSF Act, and others. The person that prepared the remedies for NSSF, share them, because I know most people understood NSSF and also the exceptions and the pension. I am sure nobody has challenges on that area. If there is, I'm at liberty to highlight. With those few remarks, allow me to salute you and wish you victory in your forthcoming exams, and may God grant us time to meet together in the future, if I'm still in Utam or still on this planet. Those are the remarks for today, and I hope everybody has understood me very well, and where there are gaps, I think or hope I've managed to explain my best so that I don't leave any stone unturned to your examination process. Yes. Anybody with the questions, now I can answer them, as I'm going to be giving you a chance to go and have something.
Yes. Doctor, I wanted to ask. Yeah?
Yes, please.
Okay, my question is about the cases that you have mentioned, Forex. Just a brief one so that someone can pick it very fast. Like, I was going to ask about, okay, let me say, for example, in case a question comes about corruption, with all the cases that has been mentioned and the corruption scandals that have happened in Uganda, at least someone can be able to mention quite many of them. So how many cases?
When it is an exam, what is reasonable is what I remark. Because now, when I look at the cases, there are very few cases. They don't even exceed or more than 6, what I've seen. The more you engage with the question, the more you score marks with the authorities. But mind you, you should do every question in 45 minutes. Make sure you plan your time very well. Because you are doing 4 questions, and I will convert your performance out of 60, then I give you the total marks. I never restricted you to few questions, because some of you might do 1 question very well and then you don't. But when you do 4, and remember, you have section A and B, and you should at least pick 1 question from each section. So really, and those cases are very few, the one we have covered. And in exam, you have brief facts and the ruling to support the narrative. Yes.
Okay, thank you, Doctor.
Boambali, what's the question?
No, I think, thank you, Doctor, for all this. I think you answered my question. My question was that what should come out from the cases, these cases? What do you want to see on
the
paper?
Cases I need to see wow, you understood. Like I've made like a summary of the brief facts and the law. What was the facts and what was the ruling in a summary form in that case?
Yes.
And why is that case? For example, you have had Mugisha discussing corruption. You have seen those cases to corruption. That's what I need. The cases should connect to the question, to the scenario, because you are advising another person. If the termination, you discuss the methods with the authority, how have the court implemented that termination methods? I have given you cases. If I've given it to you, just use one into the methods. You don't have to quote everything, because time is of essence in an exam. But if now I've given a scenario of abortion and others, you are supposed to have mastered one case, the law, as you are advising the people. If it is circumcision, whether it's sterilization, now you know. Apai Lilian, you can repeat your question, because I want to make sure that I leave other people to go, because it is too, I've stayed too long. So you ask your question again, Apai, if you say it was not understood.
Doctor, it's okay now.
Okay. Mugisha, I had something. Can you say it? Because I want to summarize up. Me, since morning, I've not eaten, even tea. I was busy talking, and I cannot eat when I'm speaking to people.
Same here,
Yes,
Doctor. Yes, Doctor, I wanted to make a comment on level of remuneration, where a person is being remunerated at some level, and later on, it's reduced when the contract is still running.
Yes.
In some, I think it was in 2005, we had our Organization Act repealed and a new one came into place. This had to come with restructuring, and some staff's positions had to be changed. So we were guided that employment law does not allow a person to be retained at a lower remuneration level, more so especially in form of salary, than what he's having. So some people had to drop off because they could not be retained, and they applied afresh. How come? I'm looking at your situation. Same contract running, then the remuneration level is scaled down. And if it's true, the provision of the employment law is that somebody is not employed at a lower remuneration level. Maybe I didn't read that clause in detail or personally, but I was requesting for a comment about it.
Now, first and foremost, under restructuring, the new employer is supposed to go with all the employees with all their terms of the contract and salary. That is the law. 2, if the employer does not want, the other people can stop there or resign, get their payment, what the other people did, so that they get paid of their contract and then sign a new one. Are you clear? So, when Ibara did the same, he put the money to 1.2 million with the stating that a person should teach five modules to be full-time. Then the US was writing to me saying 6. The human resource was saying 5. In my contract of employment, those terms are never there. Then they say, by the time we sign those contracts, National Council had not given us law. Then these means are signed by the council of the university. The letter that they are writing to me is written by university secretary with no means of the board of the council. That is already a breach. Now, I said, okay, since you never paid me 2024, 2025, you started paying me around February 2026. Pay all my arrears, NSSF, which you have never paid. Then me, I have no problem of accepting your new one of a less pay. But you don't expect me to be doing the same services as a full-time. When I have resigned, I'm no longer dean. Secondly, I'm not defined as a full employee. If I'm not a full-time employee, why do you want me to be in the office every day? So what I did, technically, I signed that new contract with its ambiguity. However, at the same time when I was signing, they had written me another document called re-engagement because the VC had stated that I'm going to go to court. Then I said, no, I never said I'm going to go to court. I said we can have avenues of mediation. So, what happened in such a scenario, I made sure when they sent me the re-engagement, they had put that I don't teach at all. And then for me, I was able to get all of my ICT evidence of my teaching. Number 2, the owner of the school had sent me messages of praising me of teaching. Now, what UTAM did, they had allowed students to do 2 semesters with no exams. So when students, a timetable was drafted for them to sit exams, they started making allegations of non-teaching. However, I have just set the paper recently, I've marked, and majority passed. Now the question that is going to be to them again, if I never taught them, how comes I set exams? The ones that one of them I taught, because others, one person came, there is a coordinator called Abel, tried to connive. And many of the students, even some, refused to attend to those classes. And they are going to sit exams. Me, I set the exam and students have passed. Now, this was a kangaroo mechanism where people don't want to pay. They find excuses. They use staff who have mediocres to fight. So next, through that document of re-engagement, I was able to give all those decisions, and I was able to explain that I got 2 contracts on such a date. You are telling me that the National Council told you not to start paying us until further notice. You cannot sign a contract between the employer and the employee and use a third party for non-enforcement. No. Secondly, you are changing my contract on payment, but you want the terms to remain the same. Never. Thirdly, You have never paid my NSSF, which is a legal mandate. So, after signing the other document, I sent both the reply from Human Resource and the other document. And I have told them within 14 days, they should clear my areas and other areas. So I left the question that way, as I still delivering the course, because if I had left and others would suffer getting another lecturer who start from nowhere and set exams. I never want a student to suffer. I want to make sure that students get the exams, I've set them, as I wait for remedies of Professor Bamleva, the owner of the school, because he's the one who makes those decisions, not the VC, because the VC has very procedure. So those are the remarks. Charles.
Thank you, Doctor.
But that's why I teach employment law, so that when you become victims, you know where to start from. When it is the wrongful dismissal, you know. Whether it is unfair, you know. Whether it's summary, you know. Because that is how most of these employers who are trying to bypass NSSF, non-payment, they try to find a mechanism of non-payment. So if you're not smart, you end up being a victim. And you assume, you know, this is the only job, what and what, then you succumb to such challenges. But you can work in protest. And then later on, whether 2, 3, 4 months, even a year, you can bring up a case in court. Because, you know, Charles, there is no way you can run away from NSSF if an employer. Can you?
No, you can't. It's not easy.
Can a person run away for changing of a contract without my consent? You change the money and you think because you can intimidate a person and the person is stupid? The answer is no. But at times, there is what I call a cancer strategy. At times, you don't come up with a lot of heat. You can go slowly like a cancer and you destroy the opponent with a lot of evidence. The more you stay with him, the more he commits more errors, they become part of your evidence to submit before court.
Yeah, because I can see the comparison. We struggled to have people fixed and to retain them at their salary scales.
Yes.
But I'm looking at a different scenario in your case.
Yes. Charles, in your case, did people go to court or it was settled?
It was settled. We had to relocate them and redesignate. We redesignated their positions and had to retain their salary levels.
Yes. Yes. So, even you who is not a lawyer, you can know the question of management. It is bad that people do sciences at times when they don't want to learn the law. And that's why I gave the other question, that lack of investigation of employers, it has cost them a lot of money. You do such mistakes, a staff goes to court, you pay him interest, you pay him damages, repetition, ABCD. From 5 million, you're now paying 100. That is the other question that I gave you, lack of investigation.
You go and remove the cooker. I think eggs are ready.
So, Charles.
Thanks so much.
I hope everybody has managed to capture and understand. And thank you for all the support. And I wish you a blessed journey back home and in preparation. And the Charles and group, those that have come in for medical support, I salute you very much. May the Lord reward you abundantly until the day of reckoning. Thank you very much. Charles.
Yes, Doctor. More importantly, may the boy heal and become an important person to contribute to the development of his country
Yeah.
and grow to fulfill his vision and missions.
Okay. Charles, you have my
Doctor,
number. You send me the number.
Doctor.
Yes, yes, please.
Yes.
Yeah, I was kindly inquiring, in case you've not yet got the records, we can get them for you from Mengo Hospital.
Okay, that is great, if you can.
Okay, I'll send you a WhatsApp.
Okay, that is great. That is great. Okay, members, make sure you can have groups, and then you can revise within the groups. Life will become easier. You can spend an hour, and an hour can be equivalent for you spending 3-4 weeks, so that you give more concentration to the other modules. Because mine, you'd have had a very good recap for preparation for exams.
Doctor, we are going to have the recap shared here, not so?
Where? I've been recapping. Haven't you been in class?
On the link.
I don't know. I don't know. That one I can't give you guarantee on ICT. But what is important, we have been covering together, we have been exchanging views, I've been typing, everything has been going on together. But what I'll do, I don't know, because the problem is when you log in first before me, you'll get you get so many links, because the links come at every person who logs in. But if I logged in earlier, me being fast, and you people log in, the links one link becomes a connection. So that one, I might ask ICT whether you can easily get this one very well. Lillian, are we together?
Yes, thank you, Doctor. Yes.
Okay, let me allow people to go and have something to eat. And thank you very, very much for the time spent and the opportunity granted that I was able to impart knowledge all this semester.
Thank you. It has been a long journey of recap.
So you don't see me in any lecture. Today I've concluded my lectures. The other time left is for you to sit down, digest. But wherever, if there is anything that is of urgency, I'm free, I'm at your disposal to come in, whether on Zoom, whether online, whether on WhatsApp, to clarify on any matter that rises up. Feel free in case. And also, make sure there is a thorough report on the delivery of the model, the understanding, and that report should be, all of you should put on your e-signature, and the report should be written to the director, the board of director, the VC, the DVC, the Dean of Business, Academic Registrar, and maybe copy to me. So that feel free to write a report, whether you need some improvement for delivery, feel free, so that the university becomes better for other people to come, even if I depart. Thank you very much.
All right.
Thank you, Doctor. We appreciate a lot.
Thank you, Doctor.
I'm sure everybody has got his own coursework online. Apart from few people that I found that they left the course, I hope everybody has got his own coursework online. I think there's one person where he sent the coursework late, but I'm sure majority of you have your courseworks. Am I clear? Am I right or wrong? Francis, you don't have your question? Your courseworks online?
I have, Doctor, I have.
Okay. So I did not want you to sit exams minus your courseworks like before. So that one is sorted. So that is it. So I wish you a blessed day. And Mugisha, make sure that you send me your number, and the other lady, Joan. Assalamu alaikum wa rahmatullahi wa barakatuh. May mercy and the blessing of Allah be blessed upon you all.
Amen.
Amen.
Amen, amen, amen.
Doctor, you don't need my number.
Amen,
Who is
doctor.
that one? Wafura?
Yes, Wafula as well.
Okay.
Doctor, I will also send you my number.
Okay.
But I have your
Amen.
number, doctor. I will send you mine, like a WhatsApp.
Okay. No worries. I think I've given everybody a chance to speak, and all questions have been answered. I don't want people to say we are segregated or we are discriminated. I hope
Doctor.
everybody. Yes, please.
Doctor.
Yes,
My
please.
coursework marks is not updated on the portal.
When did you submit? Because the coursework, I even gave extension of 2 weeks. I'm very sure you never submitted in time.
No,
When
doctor, I beg your pardon. You actually marked me on the e-learning. It's there. It is on the where we process from the exam permit that's not updated.
So what's my problem?
I'm just wondering how I can be helped.
But have you seen my marks on your portal?
Yes, I've seen.
The other part is not me. It is the academic register to do the what is needed.
Okay.
And the deans. I'm no longer dean, and I'm not part of the top management. The next part is academic register. But that one will not stop you from proceeding and doing exams. They can't.
Okay.
What is important, you have evidence of your coursework, you have been attending, because attendance is part of the assessment marks you have. So that can't impede you from assessing your room for exams. And by the way, when you do exams online, make sure you do your work, you first finish all your questions, you have put them somewhere, they are fully done. Do scanning when everything is done. This system of doing one question, then you scan is wrong. You lose time. Don't put yourself in panic. First finish your work, all the questions are done in time. Let the scanning be the last result. And you can even ask for more time if you find scanning is a challenge. Some of you that have challenges, you can seek to have exams in Kungu campus or Bugorobi so that the ICTs members to support you in your submissions. Members, I think, let me see on chat if there's any question. And I'm also going to ask Calvin, ile rafiki yangu Bwana David, I'm going to make sure you ask my ICT today. Send him a message. Even me, I'm going to do the same. That is Calvin. Let him get all these recordings, and then you will share them in the group so that other people use them for their revision.
Okay. Doctor, that is okay, but I feel like the recording is a bit long for us to be at.
I'm also going to instruct him to send that link. But at times when you go to the portal, you can also access the links of my coverage automatically on the portal. Lillian, are you getting me?
Yes, I'm getting you.
Okay. So I had Jan the lecture.